Well, account idea. Presentation. Yes.
This is criminal appeal against life sentence. So, my lord, IA was filed, that was rejected, but considering the age, it was updated, but not listed, though it was ordered on last in September. So it may be listed on 6th.
The appeal, what do you want now?
We are hearing, it is already in hearing it.
Paper
book is ready.
book has been prepared. It will come up for orders. We'll consider and fix a date of hearing. Give us any date in the next. Which date are you giving?
Then it is to be orders.
Yes, for orders. Have we done 8th? We'll fix a date of hearing on 8th.
Yes.
May I please?
Yes.
This is criminal appeal jail. I am the MI. My name is wrongly shown in the list.
Okay.
So on the last occasion, I could not appear due to my wrong name, shown in the wrong name. So this matter may be listed for order
Friday.
Friday.
Net is a lot. I'd like to mention for listing of an IA lordship. In
IA
connection
for bail,
for
suspension of sentence.
lordship, for suspension of sentence. And this appeal was admitted in the month of June, lordship, and thereafter not listed, lordship. So
Okay.
kindly for order.
You have filed the IA subsequently or?
No. At the time of lordship.
Okay, okay, Friday.
Deeply, Lord.
One to four are the jail appeals
Jail
for the
appeal.
first time.
Okay. First is 302.
30, we don't have the paper, so 302, no notice.
No
lordship.
notice, yes. Very deep, huh? Admit of jail appeal. Me, get a bit through, I'm because 302, POXO hole a special as manner prescribed as for number 2 hobo. যদি POXO থাকে, POXO নাই to 302 আৰু amicus we appoint whom? That's Navneet Kumar Barua, serial number 17. Next.
I can do.
You're under conviction. Very same. I to hobo. Appoint serial number 3, Jasodhir Das. So Das was here. Mr. Das. Serial item number 2.
I can see.
POXO আছে POXO হলে informant বা respondent took notice দেব হ্যাঁ আমি এডমিট করি support Admit call for the record support কৰিব। $25 কষ্ট প্ৰকাশ পাঠক। এইটো বক্স আছে। $36 মৃন্ময় খাটনিৰ।
Okay.
I think 5. We are against an order at page.
Why
Page 28.
Why is it before us?
My lord, I do not, last occasion also it came before lordship. My lord, question is, my lord, under the NCT Act, there is a prescribed qualification which has been amended in the year 2017. For the purpose of principle of the diet, my lord, the qualification is PhD. But the court did not accept the contention on the ground that the rule doesn't provide qualification of PhD as regard the appointment of the principal in diet. My lord, may I just sort out these small pages I have made as per your lordship's suggestion on the last occasion.
Who's for the
Putting-
education department? Madam, you're there.
My lord, in short, my lord, if NCT provides, my lord, I am giving the order of the judgment of the courts and also the qualifications. Your lordship will kindly see page flag A, my lord, just for the sake of it, my lord. Flag A in 7, my lord.
So what
this
is the matter? You just give a brief background of the matter.
My lord, there was a requirement for filling up the post of principal of diet.
Right.
Right.
Okay.
Petitioner is PhD. The persons who are not PhD are also considered by the diet on the ground that the 2010 rule doesn't prescribe the qualification of PhD. These are all recognized by the NCTE. NCTE, National Council of Teachers Education. They are all affiliated to diet, my lord. They are all affiliated to NCTE, and therefore they are bound to follow the norms prescribed by the NCT.
NCT prescribes for PhD.
Yes, this has been done in the year 2017. Flag B, if your lordship looks into 2017, they have brought in
It
This-
incorporates the requirement of PhD.
PhD. Government also, my lord, this is important. Your lordship may kindly see this flag C.
You are aggrieved that persons other than persons who are not holding PhD are also being considered.
Yes. But in respect of others, in respect of assistant professors and all, there is a government notification saying that they must be PhD. But in
Only-
respect of the principal, they have just overlooked. And the judgment of the, my lord, your lordship will kindly see this, flag C.
So what was the reasoning of the learned single judge?
Learned Single just said, my lord, 2010 diet rule is there. So in the absence of the challenge of the rules, this cannot be considered. But there,
And this prescription is under what? Requirement of PhD?
PhD under the NCT, my lord, the regulation which has been amended in
Regulation.
the year, not regulation, that notification, flag A, my lord. Flag A, your lordship will kindly see this.
Flag A of your compilation?
Yes. In exercise of powers,
But this is a notification.
yes, notification. By that paragraph has been for teachers' education hereby marks the follow. My lord, 7, your number last below, my lord, 7.
Hmm.
In subparagraph 5.2, under heading Principal HOD, for item 2, the following item shall be substituted, namely PhD degree in education or in pedagogic subject offered in the institution, 5 years of teaching experience in a teacher's education institute. So this PhD has been brought, if your lordship looks into 2014 notification. Flag B. Flag B. Lord, that regulation 5.2. Page number 3, my lord,
Just,
5.2.
just a minute.
Yes.
Yes.
Yeah, that page number 3, my lord, 5.2 qualification in respect of the principal oblique HOD, only postgraduate degree was there. So this was amended in the year 2017. So from 2017 onwards, for appointment of the principal or HOD, my lord, one has to be a PhD holder. And Government of Assam, my lord, by this notification, flex your lordship will kindly see flex C. This is important. Flex C. I'll just read first paragraph.
Hmm.
Whereas education being the subject of concurrent list and NCT being the statutory body of government of India for teachers education has prescribed norms of teaching teachers education courses as well as the qualification of teachers educations as per NCT norms and standard. Most of the fund in this regard is being borne by the Government of India for conducting teacher education programs sustaining NCT recognition. Keeping above in view, the Governor of Assam is pleased to revise the existing minimum qualifications for all categories of the post of District Institute of Educations and Training, Government BT College and State Council for Education Research and Training as per the norms and standard prescribed by the NCT as follows. So while prescribing this, my lord, they have not only lecturers are there, and it says lecturer's qualification is, my lord, one must have PhD. This your lordship will get it, my lord. Name of the cadre, lecturer, subject so and so, language, Assamese, mathematics, etc. And essential qualification, your lordship will get it, NET, PhD, and NET slate PhD from any recognition. But while doing so, my lord, they have left out this principal's appointment. So therefore, my lord, they are following this 2010 rules, where, my lord, the prescribed qualification for the PhD for the principal was, my lord, MPhil, master degree and all. Net slate was not there. So now the requirement is PhD. PhD, my lord, but for lecturers they have incorporated, but for principal they have left it out. So I will just, my lord, give your lordship 3 judgments I have incorporated. Basically, my lord, Kerala single judge judgment, which has been passed on the basis of Supreme Court judgment and division bench judgment. I will take your lordship to flag F.
Flag?
F. This is the judgment 2002 8 SCC. On the basis of this, my lord, the Kerala High Court judgment has been passed. My lord, entire, my lord, appeal by the union against the Rajasthan High Court judgment. Private education institutes conducting B.Ed courses file writ challenging order by the NCT rejecting application for recognition. Supreme Court said it is in the domain of the NCT and state government doesn't have anything to say in the matter. Your lordship will get it at paragraph 2.
Paragraph 2.
Yes. And the entire discussion. Otherwise, I can start from para 1 also. This appeal by the Union of India is directed against the judgment of the Rajasthan High Court, allowing writ petition filed before it. A private education institution conducting courses leading to the degree of Bachelor's of Education filed a writ petition challenging the order passed by the so and so for teachers education, rejecting the applications of the institutions for recognition of students. So when it was rejected, my lord, recognition was rejected, they filed a writ, my lord, the writ was allowed. So the union came before the Supreme Court and paragraph 2, my lord, this is how the enactment has taken place. Parliament enacted the act and provided for the establishment of a council for teachers' education with a view to achieving planned and coordinated development of the teachers' education system throughout the country and for recognitions of proper maintenance of norms and standards in the teachers' education system. Section 17 of the Act with which we are concerned in the present case is extracted so and so. Contravention of the provisions of the Act and consequences thereof. Where the regional committee is on its own motions or on any representations received from any person satisfied that a recognized institution has contravened any of the provisions of this Act or the rules, regulations, orders made or issued thereunder, or any conditions subject to which recognitions under subsection 3 or 14 or permission under subsection P of section 15 was granted, it may withdraw recognition. The power of recognition can be withdrawn if there is any violations of the prescribed norms by the NCT. Paragraph 8, your lordship will find object is not to lower the standard. Paragraph 9, my lord, your lordship will find, my lord, High Court committed gross error in constituting the provisions of section 17. So section 17, my lord, provides the power to the NCT to prescribe all the recognitions, and this recognition is granted on the basis of the prescriptions given by them. Now, the Kerala judgment is on the basis of the another recognition judgment I have given, 2016 16 SCC 110, that is at flag D. That
B,
is flag D.
D.
D. It says, my lord, for recognition, state is only a formal party. Paragraph 2, your lordship will find controversy is whether state has any say to grant recognition to the institutions to get recognitions of the NCT. Here, my lord, one student was allowed by the division bench for admissions in B.Ed courses. In violation, although he did not follow the guideline. Paragraph 2, 4, 5, 15 and 16. In para 9, your lordship will find case laws discussed. Flag E, your lordship will kindly see, this is important for us because it, paragraph 3, my lord, flag E, this is a Kerala High Court judgment. Vacancy of headmistress arose. Both petitioner and respondent number 7 stake claim, even though there were other seniors, only the petitioner had the qualification prescribed by the NCT. Other did not have the prescribed qualification. This is as regard the qualification. Paragraph 3, my lord. And all other important paragraphs are there, but at this stage, I would like your lordship to go into paragraph 9.
Paragraph 9,
9. No, paragraph 8, sorry, paragraph 8.
8.
8 and 9 both. Learned counsel for the petitioner countered the contention that the petitioner did not have the requisite 12 years graduate service by producing the petitioner's service book. The learned counsel for the 7th respondent fairly submitted that he is not harping upon the contention regarding the petitioner's lack of requisite graduate service. Therefore, the only question remaining for consideration is regarding the qualification required for appointment to the post of principal headmaster in teachers Training Institute. This question is no longer res integra in view of the decisions in Kerala, decisions in University of Calicut versus NCTE, followed by Exhibit P3 and P4 judgment. In University of Calicut, a division bench of this court considered the power and authority of the National Council for Teachers Education, constituted under the National Council for Teachers Education Act 1993, in issuing various directions to institutions which offer B.Ed degree course and training in the teachers' education, especially with regard to recognitions of teachers' training college and fixation of teachers' people ratio. For deciding the legislative competence in enacting the National Council for Teachers Education Act and power of NCT to issue directions, the division bench relied on the decisions of the Honorable Supreme Court in so-and-so, wherein the apex court had unequivocally upheld the authority of the NCT to decide upon the qualifications and standard of teachers training institutes. The division bench thereafter referred to the NCT norms, standard, etc. Regulation 2001, which prescribed various standards for conducting B.Ed and M.Ed courses, including qualifications of principal, lecturers, etc. of the teaching staff and held as follows. This is the finding that ultimately it says, my lord, in paragraph 9, in Exhibit P3 judgment rendered, rendered in OP so and so, the contention of the petitioner was that the NCT, being the supreme central authority competent to prescribe educational standards for teachers training institutions, qualifications prescribed by the NCT for appointment as headmasters are mandatory. And therefore, no person who does not possess such qualifications could be appointed as headmaster of the Teachers Training Institute. This contention was countered by stating that the qualifications for appointment as headmaster of a training school is prescribed in rule so-and-so of the Kerala. The learned single judge, placing reliance on the decisions of the University of Calicut, refused to countenance the argument that the qualification prescribed in Rule 44A of Chapter 14A of the Kerala would suffice insofar as the training institutes governed by the Kerala is concerned, and went on to hold that the NCT Act has been promulgated by the Parliament in exercise of power conferred by entry 66 of List 1 of the 7th schedule to the constitutions of India, whereas the Kerala Education Act and rules thereunder trace their legislative competence to entry 25 of the List 3, and as between the legislations under the two entries, the Central Act would prevail over the state enactment. This is my submission. If the two rules are there, my lord, the central act will prevail. And so therefore, ultimately, my lord, court held promulgated by the constitution, the central act would prevail over the state act. It was held that on a harmonious constructions of the two enactments, Rule 44A can be safely constituted as an additional or further qualifications to those fixed by NCT. It was held that for headmasters of teachers training institutes in Kerala, both the qualifications prescribed by the NCT and under rule so and so are essentials, and appointments of persons who do not possess both qualifications would be invalid. By exhibit P4 judgment in writ appeal number so and so, division bench court affirmed exhibit P3 judgment in the above legal background, the contention that in the absence of the amendment to the Kerala, the qualification prescribed under rule so and so is sufficient for appointment to the post of principal headmaster of TTI cannot be countenanced. Resultantly, exhibit 5 rendered on the said wrong premise is quashed. So there are one rule is there, it doesn't show that there is a requirement of qualification of PhD. Whereas the central rule shows that my lord, for PhD, a PhD is essential for the purpose of appointment of any person as the principal of the college. And in fact, my lord, following the amendment by the notification dated 2017, the government of Assam has issued a notification. But for whatever reasons, my lord, they have not included the requirement of qualifications as per the prescribed as prescribed by the NCT in that notification. So therefore, we are with two notifications. One is for the purpose of appointment of principal, my lord. One says, NCT says that there must be a person must have a PhD net or SLET. But the regulation, 2010 regulation, which is at flag G, I have given, my lord, flag G, it does not prescribe that qualification. Because at that point of time, the NCT's qualification was as such. So therefore, my humble submission is that, my lord, they made petitioner has made out a prima facie case. And if these persons who doesn't have the qualifications prescribed as per the NCTs are appointed, this will be in gross violation of the Act, NCT's provision. So therefore, my lord, the judgment passed by the Learned Singh is liable to be stayed. Also liable to be set aside. Well,
Stay of a judgment which has dismissed your petition. What is the implication?
not that, my lord.
That is the prayer. We are just surprised to see your interim prayer at page 25.
My lord, interim prayer I have seen, my lord, that was.
How do you stay a judgment which by which a petition has
Yes,
been
that
dismissed?
is there, but
No, that is
regarding.
on a different aspect of the matter, but on the merits also, see,
Yeah.
2017,
Yeah,
some changes were made in subparagraph 5.2
yeah,
by the NCTE,
yeah,
whereby there was the regulations were changed by incorporating the requirement of PhD so far as principle of that is concerned. 2017 notification was taken into account by the state government, and state government subsequently in 2020, 7/12/2020, had made necessary incorporation in its own rules. But this post was left out. Whether it's a
Yeah.
proper action or
Yeah.
not, we are not on that till now.
Yeah.
Because that is not the subject matter of challenge before us.
yeah,
Yeah, before us means before a writ court.
yeah,
We are just
Yes.
it is in concurrent
Yes.
jurisdiction. After the
Yes.
single judge, we are just. But if you see the prayer in the original writ petition
yes,
at page 63,
yes,
you have simply challenged the minutes of the DPC.
yes.
There is not even a passing
The
reference.
minutes of the DPC has taken into consideration the persons who doesn't have
They
the
have not
PhD
been
qualification.
they made a passing reference that yes, you have to do by follow the incorporation made by the NCT. It is the
That was
the
the
highest
ultimate,
body, but that is
ultimate.
not the prayer.
but that was the
How do you
ultimate.
go
but the
into this aspect?
Court looked into your lordship will kindly see what is the finding of the court.
No, we
Court
have looked
said-
into the findings. We have looked into the.
Yes, because court said, my lord, you do not, we have not challenged the 2010 rules.
Yes,
So therefore, my lord, we.
not
we-
2010,
Yes, that
not
is what it
2000
is.
not
my lord.
2010. The state notification is of 2020.
Yes, no, 2010 in the absence of challenge, paragraph 25 to 28. Page 32 onwards, my lord, this starts.
The
Page
state
32.
notifications, the state notification which you have shown to us at Flag C is of 7/12/2020,
2020.
which does not make any reference to the post of principal diet.
Principal of the college, yes.
So they are following the earlier notification, earlier rule.
But they, my lord, they cannot follow, my lord, when there is an
No, if
NCT
they cannot follow,
qualification.
Mr.
And
Das, you may be correct in contending, but where is your challenge?
my lord, your lordship will kindly see that page, I think 119.
119.
No, one.
Madam, what is the position now?
122.
The judgment is of 29/8/2024. What is the position?
Take it, take that, I have to take it.
All these days you have not even taken instruction. What has happened? You are representing the department, aren't you? Didn't you feel that you should take instruction? What has happened at least? And this is the minimum question we are going to put to you. What has happened thereafter? Not expected.
Page 122. Page 122.
122.
Office of the Director states so and so. It is addressed to the principal diet. And it says with reference to the subject cited above, I have the honor to state that as per the minutes of the 40th General Body Meeting of the NCT held on February 2019 has decided few important decisions in teachers education institutes may like to take action as follows. So the GB of the NCT has recommended for 180 days in the line of UGC in the year so and so. Number 4, my lord, NCT has issued notification dated 2017 where PhD degree in education or any pedagogy subject offered in the institute with effect from 2017 for fulfilling the qualification, the candidate that have cleared the national eligibility test conducted by the University Grants Commission, provided candidates who are or have been awarded PhD degree in education in accordance with the University Grants Commission's
How is this relevant?
regulation. So it also says them under follow 2017.
Now, how is this relevant?
No, it says, my lord, number 5,
It has got nothing to do with
Regarding
principal's
conducting a-
post.
principal
principal-
post is there
Where?
for a professor, PhD or net. It says, my lord, number 4,
Yes.
NCT has issued notification dated
Yes.
29/5/17 where PhD degree in education or any pedagogy subject
Hmm.
offered in the institute with effect from 2017 for fulfilling the qualification, the candidate shall have cleared the national eligibility test conducted by the University Grants Commission,
Yes.
provided candidates who are or have been awarded
Yes.
PhD degree in education in accordance with the University Grants Commission's minimum standards, so and so, so and so, so
Shall be
regulation
exempted. This is
2000
not
shall
relevant.
be exempted from the requirement of the NET. Next, my lord. NAT SLAT PhD of assistant professor can be any pedagogy subject or in education for teaching education 2000 with effect from 2021 for requirement of students. The principal and faculty member of all diets city are requested to fulfill the requirement as mandated by the NCT for conducting.
This is not
the
relevant because this was a letter addressed to the principal,
Principal.
nothing to do with the
So
principal's qualification.
they only invite a application for fulfilling the appointment in the post of principal. So this 2017 notification having been given, my lord, it is the duty of the my lord, authority to follow it, my lord.
No,
In
if
the
they have not
absence of-
done, aren't you required to make a challenge or make a proper prayer?
My lord, in the read petitions, my lord, we have not challenged the 2010 regulation. But at the same time, when we have shown there is an existence of 2017 and there is an existence of 2010, so the prescriptions provided by the NCT has to be followed.
No, what comes as a barrier is a notification of the state or in the year 2020.
Yes, 2020.
After making the necessary amendment in 2017, state government took into consideration all the aspects,
But-
but did not take into consideration the post of principal.
Principal, so therefore
So
I
we
have,
need to know the reason, but you have
Yeah.
not challenged.
no, let them have their
No,
instruction.
no, without
but-
the challenge, why should you ask them to have the challenge?
My lord, I have shown there is a requirement of, if NCT's regulation is there, they will have to follow the
We'll,
regulation.
we'll go by the prayer at page 63 of the read. Mr. Nayak, you're appearing for whom?
I am for SCC law, SCRT law, but
Any idea what is the present position?
that instruction I have to take, but this is basically a case not, DPC was conducted by the government department.
No, madam also doesn't know what is the present position.
Yes, sir.
No, the writ petition was structured in such a manner and the challenge was such a, in a manner that it was only the recommendation of the DPC was put to challenge. If there, as per you, there is some conflict, the conflict of the rules, NCT rules will prevail, but that petition has to be structured in that manner. The question of
My lord,
repugnancy,
your-
we cannot examine without there being a proper challenge.
No, your lordship is correct, my lord, but when we have shown that when there is a requirement under the NCT to have the prescriptions of PhD for appointment as the principal of the college, then it has to be followed, my lord. It
No,
is
that is
not
what,
necessary to-
that is what we are, it's troubling us. The requirement was incorporated in the year 2017.
17.
State on its own wisdom incorporated other requirements in 2020 and did not make requirements so far as principle is
My lord,
concerned.
in that
There may be
case,
some reason, you can challenge the reason that why have you not done?
no, my lord, even supposing, my lord, your lordship is correct, he could have, petitioner could have done it, that is different thing, my lord. But when I showed, my lord, that as per the NCT norms, one is required to have paid this is what the Kerala judgment showed. If there is a, because, my lord, that is a parliament, this is a central act. When there is a conflict between the central act and the state act, then the central act has to be followed.
Challenge to merits of human in the law. Merits of normal is a piece of one. We say this will prevail over this. But where is that? Where? There is a repugnancy in the reputation. You have simply challenged the DPC recommendation. But it has not been done that you have to follow the amendment which was brought in 2017 requiring PhD to be an essential condition for post of principal. You're only relying that 2020, in the 2020 they say, however, in case if there maybe see first you have to give them a chance. And chance when there are proper pleadings are not there. They make now up with the principal or posted both administrative work would happen. PhD may not be an essential condition. Teaching may not be an essential condition.
That may be reason for not.
No. I'm just contemplating it. It will come, definitely. Notice it again for this. Okay, at best we'll issue notice at this stage. And otherwise also there is no
Yes, ma'am.
interim.
Yes. And otherwise, my lord, Kerala judgment, my lord, paragraph 8,
Heard
that is my only concern.
3 BD Das, Lanit Senior Council, assisted by Sri Purkast for the one petitioner who has preferred this appeal against the judgment and ordered it is so-and-so, passed in so-and-so. By the aforesaid judgment, the writ petition has been dismissed. Full stop. Let notice be issued, returnable by 6 weeks. Ms. Madam, your name? B. Decker. You're a standing counsel. Ms. B. Decker, Learned Standing Council, Education Department, accept notice on behalf of respondent number 1. Whereas 3 P. Nayak, Learned Standing Council, SCERT, for 2 extra copies And what about the other private respondents?
Private respondents, we have not made it, but in other cases, there is another connected case where they have implemented themselves.
But in your case, they are
There are,
parties.
there are.
Huh?
In the writ petition, my lord, in our case, they are not party,
Jibendu Dutta not parties.
not party.
What is the other case?
Case number কত ছিল?
What has happened to that? Any appeal preferred? No,
It is also dismissed with the common order, my lord.
that is understand. What appeal preferred or not?
Uh,
No idea.
No.
Okay. That aspect will again come because you're
Yes.
lucky that two writ petitions
It
were
will
decided
come.
together. So private respondents were given an opportunity. Here,
I
if
think
they
we
do
will-
not
we will-
prefer an appeal, you might have to incorporate.
We'll have to incorporate. We'll do that by way of amendment.
This you can retain with you on the next, whenever you can give it to the court.
Obliged. Deeply obliged.
This one key. Caveat kar asile. Who's for the caveator? In the other case? Oh, it would not.
Item 6.
Yeah, please, Lord. There is a criminal appeal against the judgment in order dated 27/09/24 at page 40 in your lordship. Where he has
Against?
been, he has been convicted against 302 IPC.
Okay. Your
For
S.
acting
Ahmed. What is an S. Ahmed?
Yes, Ahmed, your lord.
S. Ahmed, huh? Admit. Call
Yes,
for
sir.
the records. Miss Ad Jahan Bennett APP. Accepts notice on behalf of the state respondent. 302, why have you made, okay, let notice be issued to the respondent to in the manner prescribed, steps within 2 days. List after, 6 weeks, along with report on service as well as receipt of paperwork, or receipt of records.
There is also an IA.
I to issue notice issue করে দিব. We'll fix a date. List
I'll-
after receipt of the LCR.
I'll file my objection in.
Objections, if any, may be filed in the meantime.
Obliged.
Six করে দিব, no? এটা কিন্তু this is an application seeking for suspension of sentence and release.
Obliged.
You take steps.
Yes.
7, item 7.
This is POXO. This is POXO, in judgment at page 48,
POXO,
my lord.
HG Borwa. Same order. Two respondents.
My lord, state.
State is the first respondent, okay,
State and the informant.
okay. You have given the entire records, why? In appeal?
My lord, because there's translation and all those, so I have.
No, why have you given the entire record? It's not, is it necessary?
Because my lord, yes, my lord, translation is there during the part of the IA, sometimes during the hearing, okay, so
You can present it otherwise also. Why do you make this bulky? No requirement.
my lord,
Criminal appeal, one page is enough.
sometimes the court asks, so my lord.
No, you can have it handy.
My
Don't make this bulky. No, does not serve any purpose.
my-
Same, huh? Or
There is an IA also, my lord.
IA in POXO. Okay, same notice, huh? Objection, so
Obliged.
same order.
Item 8.
May please, Your Lordship.
Yes.
Lordship, may I kindly peruse order dated 22/1/2024 passed by this honorable court. Here in this case, Lordship, from 313, it appeared that he was juvenile. Lordship, I was appointed as amicus curiae and thereafter I have pointed out before this honorable court.
Which
And I-
order are you referring to?
22 January 2024.
Okay. Thereafter,
And therefore, a report has come, Lordship, that a report says he is aged between 15 to 16 years, Lordship.
at the time of the occurrence.
Okay.
Yes, madam. Where is the report?
Report is there, Lordship, and in the record.
Bhuya was looking into the matter. Now we have to see whether the report is according to rules.
He
And
has also filed one objection.
today she is absent. Lordship, if
Okay,
we
we'll
can-
have it day after tomorrow.
Day
You are
after
around,
tomorrow,
day
day
after
after-
tomorrow?
Sure.
Okay. Do Sri A. Ahmed Learned Counsel, Learned Amicus is present. Comma, the concerned APP, Ms. B. Bhuya. No, a time has been sought for on behalf of the concerned APP, Ms. B. Bhuya. Para, in the interest of justice, list on 611.
Six.
Public.
A report to court, sir. You have have you got, okay, we'll ask.
Sir, got the
Okay, okay,
Just file one objection. also.
okay.
May I please? In this case, on last occasion, both the parties were present, but. it could not
Yes,
be
we had
materialized.
had an in-camera
They have
proceeding.
filed a.
Yes, where is the other side, Mr. Ghosh? Now, what is the position now?
Now it has not been materialized. LCR is in call for, let the
LCR
matter be fixed on hearing.
LCR is there, no? Heard Sri K. Gupta, Learned Counsel for the appellant. No, don't say heard. Do Sri K. Gupta, Learned Counsel for the appellant is present? None is present for the respondent. Full stop. Considering the facts and circumstances and also the order passed on the last occasion, the registry is directed to release this matter for hearing.
The-
When, any time we fix?
In the month of December, because they already did matter. Last
In the
previous-
second week of December.
the-
Lordship, on the number of occasion report from the
The
IOS.
report is here, I perhaps with the report. But it is in connection with the suspension of sentence, it seems. Lordship can see, go through one.
What does it say?
That report to the informant is informed.
That is 2 and 3. It has been served.
Uh-huh.
They
It
have
is
been served.
served upon. The signatory is
If you want.
Preeti Rana Bhatt.
No, no.
Miss Anjuara Begum has
Vibhu Sharma is the informant and victim is Sanjana Chet.
They are related,
No, no.
not related.
informant seems Preeti Rana Bhatt. Now who is he? Okay. Akhtar Khan. Haflong, no? Haflong. The case number is 48 of 24, file number. File. Case number
85 was.
85. Lordship, let me speak to Miss Anjara Begum. She has
My lord,
received it.
kindly have a look the previous order. A number of questions, this way, that way, my lord, the landed.
I understand.
Because
This is under POXO. Where was it? Section 12, red bit section 12.
say Begum submitted, some steps have been taken by the Central Harbor Officer. Where is Madam Begum? Not around.
No, she is also absent. She is in.
Wednesday we'll have.
Mile.
Okay. On the prayer made on behalf of Miss A. Begum, learned APP. Matter is adjourned to be listed on Wednesday.
Wednesday.
Item 11.
Lordship, your records were not yet received. That is why it's listed.
You are the amicus?
Yes, Lord.
Record the Hisen, eh?
Still records, yeah. 2910, okay.
Heard Miss B. Sharma, learned amicus, as well as Miss S. Jahan, learned APP, Assam, Para. As per the office note dated 29/10/2024, records have not been received from the court of the learned session judge, Nagaon, full stop. Registry, para, registry to issue urgent reminder for requisitioning the record, full stop, list after 4 weeks for report on receipt of records. Madam, you see, it may be connected with some other cases. Normally it comes. This is a matter of 2023. We are slightly,
There are co-appeals. Co-appeals.
at times, some other appeals are filed, so it's
Oh.
tagged with other.
She doesn't have papers, so she is unable to find out.
Have a look at the
Item 12.
Wait, please, Lord. Lordship, office note dated 4/10/2024.
Hmm.
Note, ID card was not returned, but as per report of consignment freight, it was served. Office note dated 4/10/2024.
Oxford. Hearing court.
This is under what, IPC or POXO?
IPCL, 302.
When
Okay.
it is served, that is enough. Lordship can take
We
it
can
up
have,
for hearing.
we can have some legal aid counsel or amicus. Let them assess the court. Peruse the office note dated 4/10/2024 regarding on the aspect of service of notice upon the respond number 2. Full stop. As the respond number 2 has not appeared in spite of being served, we appoint 3. Can I give a list?
April or
So, G. Borua. Madam Borua, you're in the amicus list, okay. You assess the court, okay, for respond number 2, SG Borua, serial number 28. Registry to furnish a copy of the paper book to the learned amicus, and her name may be reflected in the cause list. List after 6 weeks. You have paper book?
This already.
I have. We all have.
Item 13.
I put it, I
Mr. Ahmed, what is this paper book is there?
Paper book is there.
Here in this case, Lordship, interlocutory application is there for suspension, paying for suspension of sentence and releasing him on bail. Here, the entire case, what I find, Lordship, is based on the evidence of PW 4 and 7. 7 is the wife of the deceased, who says, Lordship, that the victim was called by the appellant on a particular date. And thereafter, on the next day, the
Eyewitness.
not eyewitness, Lordship. Last
Circumstantial.
thing theory they tried to bring on, Lordship. And on 18th, he was taken by the appellant. On 19th, the appellant came to the house of the deceased. And when wife asked, he said, Lordship, that I have killed your husband. And thereafter, he ran up. And after
Extrajudicial confession.
that is in the written in the judgment, Lordship. And thereafter, after 6 days, Lordship, on 26th, FIR was lodged, alleging that the appellant, along with 7 others, now 7 others come in the FIR.
Information lost by the wife,
Wife
who claims that she was informed
informed.
and she takes 6 days to inform.
6
the
days
police.
to inform, and 7 person was included in the FIR, that along with 7 others, the appellant has killed. And the PW4, who is the brother of the deceased, he says, Lordship, that after recovery of the dead body,
Madam, we'll hear this matter. We'll fix it.
That
Paper book is there.
Lordship.
If this is the circumstance, perhaps
Hmm.
it might need expeditious hearing. Okay, tell us the date.
if possible, this week, Lord.
Hmm?
If possible, here only difficulty is that, Lordship, his wife has recently died, and one minor children is there 7 years. No one is there to look after
One
her.
minor children,
Uh,
one
one-
minor child.
Child.
One minor child, Lord. Sorry. So because of that, Lordship, may I pray for an early date here
Okay.
this week?
Though there is an application for suspension of sentence and release of the appellant on bail, we have seen that the paper book is prepared. Full stop. The learned counsel, Sri Ahmed, has submitted that recently the wife of the appellant has passed away and there is a minor child. Full stop, para. Considering the above, raised to release this case, please this appeal for hearing on
On 7th, Thursday.
we'll have it on 21st of November, Thursday,
21st of November.
21st.
Outlet.
How many witnesses? 7 numbers?
8 weeks, 9
Eight.
Many.
Okay.
Including the officials.
weeks. This Lordship, POCSO matter service is complete.
He appeared.
Respondent appeared.
His his
Okay.
name is shown. No, M. Dr.
I have not accepted the I.
Okay, names are not shown. When
No,
she
it is
entered-
shown.
Hmm?
In the second column, I mean, in the appeal,
This is item number
14.
40.
14, okay. Okay. You give serve a copy of the IA upon him.
May I pray one thing, Lordship, that although I is pending, Lordship, but paper book is already prepared, they have appeared. So may I pray
Have
for
you been served with
No,
the
no.
paper book?
Not,
Paper book?
not it.
Okay, will the direct serve.
after serving registry, serve their
Okay,
paper book?
so
Lordship?
you serve a copy of the IA also. In the meantime, we'll direct the registry to furnish a copy of the paper book also.
My prayer was to lease the matter for hearing the last.
Understood, that is what we are doing, but in the meantime, let him have the entire paper.
I will
Okay.
serve.
Okay. Heard 3A Ahmed Learned Counsel for the appellant, as well as Miss Ad Jahan Learned APP Assam. Full stop. Your name? Sri K.M. Bora has entered appearance for the respond number 2 and has submitted respond number 2. The Learned Counsel for the parties have submitted that copies of the paper book which has been prepared have been served upon them. Full stop. Let the since let a copy of the IA be also served upon Sri Bora by Sri Ahmed during the course of the day. Since the paper book is prepared, list this appeal for hearing. In the first week of January.
No.
The first week to now, second week of January, 2025.
Obliged.
My lord, yeah, the service is awaited. My lord, a note has come from the Honorable Court of Session Judge that a criminal appeal number 231 of the 2024 has been filed here. The records have been sent there. So, my lord, may I pray that this may be taken along with it?
What is the number?
Criminal appeal 231 of the 2024.
Miss H.G. Barua. Oh, no, heard Miss H.G. Barua, learned counsel for the appellant, as well as Miss H. Jahan, learned so and so. Sole respondent.
No, my lord, they are, here I am for the sole two respondents, state and informant.
Informant has appeared.
No, my lord, service is awaited.
Okay.
So, no, like, my lord, already connected appeals are filed. There are many accused persons. So, my lord, from criminal appeal
Serve
231.
notice. Do office notes reflect that service upon the
Respondent number 2.
did you take steps?
My lord, I took it.
But there is an office note that you have not taken steps.
My lord,
When did you take steps, madam? Has been received back. No, you have taken steps. Key color? Upon the respondent number 2 is not complete, the learned counsel has informed that there is a connected criminal appeal being criminal appeal number 231/2024, in connection with which the records were called for. Full stop. List this appeal along with the aforesaid CRL appeal number swings.
obliged, my lord.
May I please, Lordship, they have filed their objection to the matter come up for consideration of bail and matter relating to POCSO, Lordship. Service is awaited. Objection filed, Lordship.
You have not taken steps.
Then I may be allowed.
You
to
take steps.
Lord.
Do written objection has been filed on behalf of the state respondent. Office note dated 29/10/2024 reflects that steps for service of notice upon the respondent number 2 is yet to be taken. Sri, your name?
Ayush.
Ayush Chaudhary, Lordship.
Sri Ayush Chaudhary, learned counsel for the applicant, praised for and is granted 2 days time to take steps, both on the appeal as well as on the IA for service of notice upon the respondent number 2.
Deeply aware.
List after 6 weeks along with service report.
Deeply.
Records called for already.
Records call for.
Already called.
I see.
It's here. Records are here. LCR 3 files.
Item 17.
Objection. Okay.
Yes. What? Yes, filed this IA very recent. We are yet to file our objection.
Okay.
Even
Parma-
How is Paramatma aggrieved? You are the
Paramatma.
Paramatma.
Lordship,
What is your name? Paramatma.
Paramatma.
Paramatma
Paramatma should be somewhere else. Why in the court? Not in this earthly world. Go somewhere else.
That too in bed.
And who could level an allegation against Paramatma? Heard Sri A.R. Shom, learned counsel for the appellants, who has filed this IA for suspension of sentence and release on bail. Para? Notice issued here.
No, Lordship, first time.
First time.
That notice be issued. Miss लिख दिबा as Jahan number 1 or steps for 2 in the manner prescribed after 6 weeks for service of notice for service report under respond number 2. In the meantime, objections may be filed.
Oblige, your Lord.
Item 21, supply list.
That is perfect. But here in this matter, we have received the paper. I is sending. They are my senior will be here.
For IA.
Yes, sir.
IA for what? Suspension.
Suspend.
Suspension of
Conviction under
302.
302.
302.
how
I
many
filed my
witnesses?
objection.
They have filed already
How
objection.
many witnesses?
12 witnesses.
Hmm?
12,
13 witnesses.
13 witnesses. 13. Attached,
Eyewitness.
Lordship? Yes, Lordship. That's the main point, Lordship.
Paper book is prepared. Why are you wasting your time with the IA?
Lordship.
Okay, we'll have it day after tomorrow, but we'll fix a date of hearing. On the prayer made on behalf of Sri T.J. Mahanta, learned senior counsel for the appellant applicant, matter is adjourned to be listed on Wednesday. Date.
Oblige.
Miss H. Jahana is
Okay.
present for the state.
Alright.
APP.
Item 18.
Please, your lordship, that's a conviction of 302, my lord, for life imprisonment. Prosecution story is based on solely on evidence PW5, my lord, who is the direct witness, my lord.
You are an amicus?
Yes, ma'am.
Mr. Das would be appearing in this case. Eyewitness.
Yes. Page 4 of the paper book is the affair, my.
Please read.
Humble submission is that around 7 PM on 27/2/2019, my son-in-law, Sri Deepak Orang, son of Sri Bodhu Orang, a resident of Longswell series line quarrel with my daughter Srimati Arshita Naresh, aged about 40, over some domestic matter and caused serious injury to her by hacking her head with a dowel. Although the people of the line immediately took her to Longswell Medical, she died on the way. I therefore request you to take necessary action in this regard and oblige. Informant is the,
Son-in-law.
yes, father
No,
of
no,
the
father,
deceased,
father, no,
father
father
of
of
the
the deceased, father-in-law of the
accused.
appellant.
Page 8 of paper book, my lord, it's PW1, deposition of informant matter. May I read?
Page?
Page 8, PW1, informant evidence.
Naru is the PW1 informant.
Informant matter. I am the complainant of this case. The deceased Arshita Naresh was my daughter. She was given in marriage to the accused Deepak Urang. The accused and my daughter used to reside at Terrace Line of Longswell. My deceased daughter had 3 children. I do not know the names of those children. The occurrence took place in this year, but I do not remember the date and month. One day in the evening, someone had informed me over mobile phone that my daughter was killed by the accused. I also heard that my daughter was taken to Longswell Hospital, so I went there. I saw her dead body there. I saw cut injuries on her neck. At that time, police was also present in the hospital. Police took away the dead body of my daughter to the police station. Thereafter, I was called to the police station and then I lodged an ejahat. Exhibit 1 is the ejahat, 1 is my signature. In cross, he stated that he has no mobile phone. It is not I have no mobile phone. It is not a fact that I did not state before police that I noticed cut injuries on the neck of my daughter. It is not a fact that I have.
Otherwise also this is hearsay.
Hearsay, Mike. Not
He
a fact.
heard from somebody on the
Somebody
mobile
else,
phone.
my lord.
Maybe somebody else has got a
PW
mobile phone, but that is only a hearsay. He heard from somebody.
Yes, my lord. PW2 is also hearsay evidence, my lord. He happens to be the father of accused, my lord, appellant accused.
Buddhu.
Yes,
Buddhu.
Budhu Orang.
Okay.
I know the complainant Nadu Orang. He is the father of the deceased Arshita. Deepak Urang is the husband of the deceased. Deepak Urang is my son. The occurrence took place in the month of February this year, but I do not remember the date. The occurrence took place at about 7 p.m. My son and the deceased used to reside in a separate house near my house. They had 2 sons and 1 daughter. At the time of occurrence, the 2 sons of the deceased were watching TV while their daughter was sleeping. My wife is still alive. There are 3 rooms in the house of my son. In one of the rooms, his sons were watching TV, and in one room inside the house the occurrence took place. After the occurrence, the sons of the accused raised hue and cry, and on hearing their cries, I went to their house. I saw that my daughter-in-law was lying on the floor and she had cut injuries on the backside of her neck. As she was bleeding from that wound, I had tied the wound with a gamusa. On my other son, Gamsen, brought a thela, and in it he took the deceased to the hospital. Doctors at the hospital had informed police. Police had visited house of the accused and had taken some articles. Police said one sack, some cut hairs, one blanket, and blood samples from the floor and one dove. I put my thumb impression in the seizure list. PW3 is the Ganesh Bhumis, my lord. He is the nephew of the deceased, my lord. He is also a hearsay evidence, my lord. And he's deposed that he could not see the injury of the deceased, my lord. Page 12, my lord, second paragraph of his evidence, my lord. The proprietor of the garden,
Read slowly, read from the beginning.
my lord.
I know the complaint.
I know the complainant Naru Orang. The deceased Arshita Orang was my maternal aunt. The accused Deepak Orang is the husband of Arshita Orang. The accused took place in the month of February this year.
Occurrence, not accused. Occurrence took place.
Sorry, ma'am. The occurrence took place in the month of February this year. I do not remember the date. There are 4 houses between my house and that of the accused. At about 8 p.m. on the day of occurrence, I heard halla in the house of the accused. I went there immediately, but at that time I could not find the injured in their house, as because she was already taken to the hospital. In search of Archita, I went to Longswell Central Hospital. On arrival at the hospital, I found that Archita was already dead. I could not see the injuries upon the body of Archita. The chowkidar of the garden, Kiran Karmakar, alias Sansura, had informed police. First, police came to Longswell Hospital and then to the place of occurrence. When they came to place of occurrence, I also arrived there along with the police. I saw that there were bloodstains on the floor of the house. I also noticed that there were some cut hair strands on the floor. Police picked up one blanket and with it they took samples of blood from the floor. I was present when police says the said blanket, one gunny bag, some black hairs, and and also collected blood stains from the floor. Exhibit 2 is the seizure list, and 2.2 is my signature. Police had also said a blouse and petticoat. Exhibit 3 is the seizure list, and Exhibit P1 is my signature. People were telling that the accused had committed the offense. Amir Urang, Samir Urang, and daughter Enika Urang were present in the house. They were the children of the deceased. And cross before filing of Ejahar, police visited the place of occurrence. On the next day of occurrence, I have visited the place of occurrence. I do not remember the place where I had put my signatures in the seizure list. The police had read over the contents of the seizure list to me. The sister-in-law of the accused told me that at the time of occurrence, Amir Urang, Samir Urang, and daughter Enika Urang were present in the house. At the time of occurrence, the sister-in-law of the accused was present at the place of occurrence. Next one is my lord, PW 4, page 13. Ma'am, I know the
He's the
complainant.
Chokidar.
Chokidar, he is the Chokidar, my lord, who informed the policeman. I know the complainant, he is the father-in-law of the accused. I knew the deceased Archita Naresh. She was the wife of the accused. In the month of February this year, the occurrence took place. I do not remember the date. At the time of occurrence, I was in my house. My house is situated at a distance of less than half kilometer from the place of occurrence. At the relevant time of occurrence, some persons of my locality told me that accused had committed murder of his wife. I immediately went to the place of occurrence. I saw that injured Archita was being loaded in a push car. She had a bandage injury on her neck. When Archita was taken to hospital, she died before she reached the hospital. Even then, she was taken to the hospital and doctors declared her dead. Doctors told me to call police. Accordingly, I gave the telephone number of the PS police station to the doctor and he informed police. Within next 30 minutes, police reached the hospital. Police took away the dead body. That the police also visited the place of occurrence and I accompanied them. The occurrence took place inside the house of the accused. I saw that there were bloodstains on the floor and those were covered with a blanket. Police picked up the blanket. They also found strands of cut hair on the floor. The accused showed police a sharp weapon in the kitchen. The sharp weapon was kalam patari, which contained bloodstains. The said sharp weapon was about 2 feet long. Police also seized one blouse and petticoat. Exhibit 2, Exhibit 3, and Exhibit 4 are the seizure list, and Exhibit 22, 32, and 41 are my signatures. At the time of occurrence, Samir Urang, the son of the deceased, were present in the house. In fact, the deceased had 2 sons and 1 daughter. I do not know the names of the second son and the daughter of the deceased. I asked Samir Urang as to how the occurrence took place. Then he told me that his father had committed the offense. Exhibit 5 is the inquest report and 5.1 is my signature. When the dead body of the deceased was taken for postmortem examination, I saw that the deceased had sustained a cut injury on her right side of her neck. In cross, police recorded my statement. I did not tell police that Samir told me that the accused had committed the offense. I also did not tell police that at the time of occurrence, the 2 sons and daughters of the deceased were present at the place of occurrence. I did not tell police that the dove was recovered on being shown by the accused. It is not a fact that I have deposed false evidence by stating that Samir told me that accused had committed the offense. It is not a fact that accused had led police to the recovery of.
Is there any statement that the appellant was found at the place of occurrence by him? No.
No. That
Till
that-
now, nobody has said that he was found there.
no.
till,
That the
PW
five and 6
4. 5 is the son, I think.
son, my lord. Son has informed the other persons, my lord, who are relatives, and independent witnesses also heard from his son and other witnesses, my lord, regarding the occurrence, my lord.
PW 5 is
Five is the son,
Amir.
elder son of the deceased, my lord.
I think not the elder is Samir.
No, my lord, his age is 15 years. Next one, PW6 is 12 years. He is second son, my lord.
Okay, but what was the reference to Samir here then at page 14, second paragraph, first line?
At the time of occurrence, Samir Urang, the son of the deceased, were present. In the house.
In fact, please read.
In fact, the deceased had two sons and one daughter. I do not know the names of second son and the daughter of the deceased. So Amir happens to be the first son. By age, I am
Okay,
stating
okay,
he might be little bit.
okay. Yes, you're an intern. Sit down. There are seats, don't stand. Yes.
PW5, Amir Urang. I know the complainant Naro Urang. The deceased Arshita Naresh was my mother. The accused Deepak Urang is my father. The incident took place on 27 to 19 at about 7 p.m. At the time, I was in my house. On that day in the evening, my father returned home under the influence of liquor. Hence, my mother used some hard words towards my father and asked him to go out of the house. After some verbal quarrel, my father became angry and dealt a down blow on the back of the neck of my mother. My mother fell down immediately. I saw the occurrence. There was hue and cry and hearing at the same. Our neighbors, my grandfather, Bodhu Orang, my parental aunt, Gita Orang,
Paternal. Not parental, paternal.
sorry, my bad, paternal aunt Gita Orang came to our house. At that time of occurrence, my younger brother, Samir Orang, and my sister, Ani Orang, were also present in the house. Someone brought one fella and in that fella, my mother was taken to the Longswell Garden Hospital. I accompanied my mother to the hospital, and till then, my mother was alive. Immediately after she was admitted to the hospital, she died. I came back to my home from hospital. My uncle Ajay Patter remained in the hospital. On the day of occurrence at night, police came to our house and examined me. Police inspected our house. Police also produced me before the court, recording my statement, and accordingly I gave my statement before the magistrate. Exhibit 6 is my statement recorded by the magistrate, and Exhibit 6(1) is my signature. Police also brought my younger brother Samir to the court for recording his statement. My father used a bill hook, Kolom Kotari Dao, to assault my mother. In cross, I was in class 9 at the time of occurrence. The front door of our house is situated in the northern side. There is a road in the northern side of our house. On the western side, there is a paddy field. On the northern side, there is a house of my aunt Gita Orang, and on the southern side, our domestic garden is located. My mother fell down on the front door of our house, and she was lying there under injured condition. There is no road behind our house. It is not a fact that I had stated before. It is a fact that I had stated before police earlier that on the back side of the door of our house, my mother was lying in injured condition. It is not a fact that on the day of occurrence, I was not present in our house. I have not seen the Kolam Kotari Dao, which was allegedly used by my father to assault my mother in the court today. It is not a fact that my father, out of anger, did not assault my mother with a dao. Page 164 is at page
Just a
90.
minute, just a minute. তার 15 years ছিল আমি তার 15 পরিমাণ আলাদা বলতো 12 to police 15 at কেন মানে file district কেন how do you 15 child হয়েছে এটা কিন্তু পরিমাণ যে এটা পুরো আছে নিয়ে ফটো দেখুন না এটা ইন্টারেস্টিংলি এটা তো একদম ভিন্ন বলা আছে certain his competency তো কেউ বুঝতে পারেন না আমরা তো ভাবছি ডিসিশন নাম প্রশ্ন দিবে প্রশ্ন ভালো কথা তারপর তো দিকে তারপর তুমি এটা কি কিন্তু হবো না এখানে কি দেবো না আমার ভুল না শরীর থেকে বলে দিচ্ছি হয়ে যাবে Just it was just দেখছিল মানে just a matter of point মই হেলথৰ একটু সবক কইছিল তো এক্সামিনেশন দে করলে বলে Yes, madam. Please
Yes.
proceed.
164 is page 99, my lord, of the paper book, exhibit 6.
Of Omir.
Yes, my lord.
One six four. At page
No, my lord, it's page 99, my lord.
164 statement.
Yes,
99.
9900. Amirullah.
Okay. Amir is PW 5.
PW 5. Exhibit 6.
He's the second son, yeah, eldest son.
Yes, my lord.
Yes, please read.
My name and address as mentioned above are true. At about 8 p.m. on 27/2/2019, while I was going to sleep after having dinner, a quarrel took place between my mother and father Deepak Orang. I was not asleep at that time and I saw the quarrel between my father and my mother. At that time, I tried to disengage them from the quarrel, and when my mother
Disengage.
disengage them from the quarrel, and when my mother went to open the door, my father dealt a down blow on my mother's neck from behind, and my mother fell to the ground. I witnessed the aforesaid incident. My father went away after hacking my mother. When I screamed, my grandfather Budhu came and people gathered there. My mother, in an injured condition, was taken to the hospital in a pushcart. but my mother died in the hospital. I do not have anything else to say. So he confirms the incident, my lord, but little discrepancy that he said that his father his father went away, but other corroboration of the evidences are there, my lord. That father himself took the deceased to the hospital. He accompanied the deceased, my lord. So
Who
that
has
part,
said, who has said so?
that PW1 informant, my lord.
PW1 did not say.
Uh,
Till now, nobody has said. If you
till
not,
after 6, my lord, other evidences has
let us see. Let us see. Something may come up.
uh,
Let us read serially after Amir.
my lord.
Amir
Next,
after
next
Amir, Samir.
Samir, my lord. PW6 is the second son, my lord.
Okay.
First question, sir, my lord, question number 1 to 5. These are testing question for competency, my lord. Lordship, go to the last part of page
Yes.
17, my
Yes.
lord.
Do you know?
Yes. Do you know Naro Orang? Yes, he is my related brother.
Yes.
Who was Arshita Naresh? She was my mother. Who is Deepak Orang? He is my father. What happened to your mother? She is now dead. How your mother died? My father took life of my mother by killing her. Do you know the day of occurrence? It was Friday. I cannot say the date, time, and year. It was at what time the incident took place? At night. Where the incident took place? In our house. Who were present in your house at the relevant time of occurrence? My brother Amir, sister Annie, and myself. Why your father assaulted your mother? A quarrel took place between them. What type of quarrel took place between them? In connection with money. Did you witness the incident? No, I was in another room at that time of the incident. How many rooms are there in your house? 5 rooms. Who told you about the incident? My elder brother Amir told me. What was the injury of your mother? It was on the neck. My mother was shifted to the hospital. Did police produce produce you before court? Yes, I gave my statement before the magistrate. Exhibit 7 is my statement, and Exhibit 7.1 and 7.2 are my signatures therein. What weapon was used by your father at the time of incident? It was a column dao in cross. What were you doing at the time of occurrence? I was watching TV and I was watching a movie in a loud volume. What was happened thereafter? My brother Amir came weeping to my room, and as such, I came out of the room. I came out of my room and saw my mother lying in the front door of our house. What is the description of your house on the frontal side? There is a door on the front side with a veranda, and thereafter it was a road in front of my house. Whether you said to the police earlier that your mother was lying on the back door of your house? Yes. Whether you stated to the police earlier that your brother Amir told you about the incident? No. whether it is false that you were not present in the house of the fateful day? No. Page 101 is his 164 statement, my lord. Exhibit number 7.
Yes.
As the witness is below 12 years of age, questions are put to him, know his level of understanding. What Lordship may skip to next page, my lord, 102. Page number 103. Second paragraph, my lord. A couple of days ago, at about 8 p.m. on 27 to 19, a quarrel took place between my father and my mother. I was watching television at that time and witnessing the quarrel. I went near my parents. My brother Amir Urang also witnessed the quarrel with me. Before the quarrel, my father went to sleep and my mother scolded him badly. Thereafter, when my mother went to sleep, the quarrel broke out again and a fight ensued. Later, my mother went to open the door, and before she could open it, my father hacked at the neck of my mother with a dao from behind, and my mother fell down. Blood came out from my mother's neck, and when I had my brother's scream, Odhu came and my mother was taken to the hospital in a pushcart. I did not go to the hospital. I do not have anything else to say. In 164, he stated that he himself witnessed the incident, my lord. But
No, he did not say.
no, my brother Amir also witnessed the quarrel with me, my lord.
No, then you read. I was watching television at the time
Yes,
and
my lord.
witnessed the quarrel.
But so far as
My brother Amir also witnessed the quarrel. This was the first part.
no,
Before the
Second part.
quarrel,
yes,
my
my lord.
father went to sleep and my mother scolded him badly. Thereafter, when my mother went to sleep, see, the quarrel was going on for some time.
For some time, my
He saw it the first part.
first instance.
Thereafter, when my mother went to sleep, the quarrel broke out again and fight ensued. Later, my mother went to open the door and before she could open, father.
Hacked her.
He was inside in the house,
In the house, my lord.
but
But
the actual
another
hacking he did not witness, or rather he had not claimed to have witnessed.
my lord.
Okay.
PW7 Wilson means, my lord, he is elder brother of the accused, my lord.
Age?
Page 19.
Yes.
I know the complainant Naro Orang. The accused Deepak Orang is my own elder brother. The deceased Archita Norris was the wife of the accused. My house is situated at a distance at about 50 yards from the house of the accused. The occurrence took place on 27 to 19 at about 7-8 p.m. At that time, I was in my house. I heard hue and cry of the children of the accused stating that their mother was beaten by their father. Immediately, I went to the house of the accused and saw that the deceased was lying inside the house with neck injury. Many villagers gathered there. Some persons brought thala and took Archita in that thala and shifted
No,
to
not
the,
very relevant,
not very relevant. Right.
not relevant.
Inquest report, he put his signatures, my
That
lord.
is an inquest witness, nothing else.
Next one is, my lord, PW 8.
Gita,
Gita, my lord. She happens to be the sister of deceased, my lord. I know the complainant Naro Orang, who is the father-in-law of the accused. The deceased Archita Naresh was the wife of the accused.
Gita, who is Gita?
Gita Orang is sister, my lord, of the deceased, as stated
No,
by
no, no. She is the wife of Gulshan. Gulshan is the younger brother of the appellant.
in one of the evidence, my lord.
No, see, Gita Orang, husband's name Gulshan. Page 21.
Yes, my lord. She is
She is
wife
the
of
wife
Gulshan.
of Gulshan. Gulshan is the
Sister-in-law.
brother of the appellant.
Sister-in-law.
Sister-in-law.
Sister-in-law, not sister. On 27 to 19, the incident took place at about 7 p.m. At that time, I was in my house. At that time, Samir, the younger son of the accused, came to my house and told that his father killed his mother with a dao. Immediately, I went to the house of the accused. My husband also followed me. I saw Archita lying on the ground inside the house. I saw neck injury of Archita. The accused was standing in front of the Archita. Thereafter, Archita was taken to Longsall Hospital. Thereafter, I came back home. Later, I heard that Archita died. It crossed my house at a distance of 50 meters away from the house of the accused. When Samir came to my house, I, along with my husband, was present in our house. Page 22. It is a fact that I stated before police earlier that Samir came to my house to call me to his house. I did not state before police earlier that Samir told me that his father killed his mother with a dao. It is not a fact that I have deposed falsely that Samir came to my house and told that his father killed his mother with a dao. Except the presence of accused, my lord, she told about the presence of accused in her evidence, my lord, which is not stated by PW 5, my lord. In 164, he also told that father was fled away, my lord. PW 10, Sanjay Bhumis. He is a daily waiter, my lord.
Who is PW 9?
9 is, it's a garden employee, my lord.
Not relevant or what?
Not much relevant. He stated that what happened, he cannot say exactly in his evidence, my lord. And he, upon a heard hue and cry, he came out of his house, went to the house of accused, and he even did not enter the house, my lord. And he is exhibit 2. He put his signatures, my lord.
Caesar witness.
Caesar witness.
Yes.
PW 10, page 24, my lord.
Sanjay Bhumis.
Sanjay Bhumi. He happens to be an independent witness, my lord. I know the complainant Naro Orang. I know the accused also. The deceased Archita Orang was the wife of the accused. The occurrence took place on 27/2/2019. On the fateful day at about 6 to 7 p.m., I was present in a shop which was at a distance of 5 meters from the house of the accused.
500 meters.
500 meters from the house of the accused. Suddenly, some persons, namely Ajoy Pator, came and shouted that one person was killed. On my inquiry, Ajoy Pator informed me that the accused killed his wife. Local people shifted the Archita Orang to the hospital by a handcart of Gulshan Means, the brother of the accused. The accused also went to the hospital. I also went to the hospital, but doctors declared Archita Orang as brought dead. Immediately, police came to the hospital, and thereafter police went to the house of the accused. I heard that one dove was seized by police. Police took my signature in the seizure list. White Exhibit 8, Exhibit 11 is my signature. In cross, Ajoy Pator resides near the house of the deceased Archita Orang. Police recorded my statement. It is not a fact that I stated before the police that accused killed his wife. The injured was accompanied to the hospital by many persons, but I could recognize only Gulshan Means and the accused. It is not a fact that Ajoy Pator did not tell me that the accused killed his wife.
This will also not have much of a difference, even
Much
if
difference.
even if Ajay Patar would have told him, Ajay, it's hearsay.
PW 11 is the garden worker, my lord. He is also hearsay evidence. He even did not see the injuries also, and he is a seizure witness in Exhibit 8, my lord. Exhibit 2 is his signature. And in cross, he very much stated that he has no personal knowledge about the incident matter.
Okay.
Next one is page 28, PW 12, my lord. He is one of the brother of the accused, my lord. Nipen Orang.
Yes.
I know the complainant Naro Orang. I know the deceased Archita Naresh. She was my sister-in-law. The accused Deepak Orang is my brother. The accused married the deceased in the year 2001. The occurrence took place in the month of March 2019. At that time, I was at the Idam TE. On the fateful night at about 11 p.m., I was informed over phone by Bipen Orang that the deceased was killed by my brother accused. On the next day morning, I came to the PS. I saw the dead body of Archita Naresh. The police took the dead body for post-mortem examination. The police brought wearing apparels of the deceased like blouse, mekhela, bangles, and chain. Exhibit 3 is the seizure list and said wearing apparels of the deceased, and Exhibit 3 is my signature. The postmortem examination was in cross, my lord. The postmortem examination was conducted at about 4 p.m. on the next day of the occurrence. The dead body was wrapped with a cloth while the victim was wearing own apparel. The wearing clothes of the dead body was removed before the postmortem examination was done. I have not seen removal of clothes from the dead body of the deceased, and hence I cannot say what clothes were wearing by the deceased. Those wearing apparels were put in plastic cover and handed over to me before I gave it to the police. The dead body was accompanied by police constable to the hospital. Thereafter, the dead body was taken to home to perform last rituals. I did not visit police station after postmortem examination. The police obtained my signature in the morning on a blank paper. I did not state to the police earlier that Wepan Orang informed me about the occurrence over phone. Next one, PW 13. He is the medical officer, my lord. Page 30. On 28/2/2019 I was working as a medical and health officer, number 1, at Tinsukia Civil Hospital. On that day, about 3 p.m., I conducted postmortem examination on the body of Asita Norris, 40 years, female, in connection with Dumduma PSDD entry number so-and-so. The dead body was brought and escorted by so-and-so, brought and escorted by UBC 619 Madhav Datta and Wilson Means, brother-in-law of the accused, of the deceased. My examination, I found the following. Injury is 1, my lord. Single injury he has described, my lord. A sharp incised wound of size 25 into 5 cm, bone deep. It was extending from left side of occipital bone to the right side angle of mandible with extradural, subdural and intracerebral hemorrhage. Membranes were cut and underlying vessels and brain matters were also incised. In his opinion, my lord, he stated death was due to shock and hemorrhage caused by the injuries as described, which were antemortem in nature and caused by sharp cutting instrument and homicidal in nature. Approximate time since death was 12 to 24 hours. Exhibit 9 is the postmortem report. 9-1 is his signature matter. And he has also gone through the inquest report, which is Exhibit 5, and put his signatures there also, my lord. There was only a single injury found on the dead body. The occipital region lies at backside of the head. There was no injury over neck.
Why has he signed on the inquest report?
Along with the dead body, I also received the inquest report. Only that much he has deposed, my.
Inquest is not done in his presence.
In his
So
presence.
how could he have signed?
I had gone through the same.
His statement is enough that he had gone through the inquest report. There's no necessity.
No necessity
He is
to.
not a witness to the inquest.
No.
How could he sign?
He has to only prove that postmortem report.
Postmortem,
Only
he's done it,
postmortem.
exhibit 9.
Yes, my. And postmortem report is placed at
No opinion we have seen, and that is a single injury.
yes, madam. Only one injury, and he prescribed to the it is homicidal, madam.
Where is the PM otherwise? 106.
106, my lord. Exhibit 9. 107, that own parts, position and character, it is stated, my. And opinion at page 110, my. Same thing is reflected, my, as per his evidence.
Just a minute. Yes, please.
Next one is PW 14 matter,
1-4.
1-4, page 32. He is brother of the deceased man. The complainant is my father. The deceased was my sister. The accused is my brother-in-law. The occurrence took place on 27/2/2019. On a fateful day at about 8 p.m., Wilson Means informed me over phone that my sister was assaulted by the accused and she was taken to the Longsall Hospital. Hearing this news, I, along with my father, my wife, and others, immediately went to the Longsall Hospital. I found that my sister was already dead. I saw injury on the head of my deceased sister. In pros, Amir and Samir are the sons of the deceased. I met Amir and Samir in the hospital. I did not visit the house of the deceased. Police took the dead body from the hospital. PW 15 is the investigating officer, my lord. Page 33.
নাম্বার বরাবর মানে কোন কোনে না নামও কোনে না কিবা কইছে একবার বকন না বলিও হ্যাঁ ওয়েস্টেজ অফ টাইম আহি বলে হইছে একই না বলে Yes, next.
PW 15, page 33.
Yes, please.
On 27/2/2019, I was working at
Ayo.
I was working at Dumduma PS as probationary officer. On that day, at about 8:30 p.m., an information over phone was received from Longsall Central Hospital by Dr. Nirman Gogoi that one woman, namely Archita Naresh, wife of Deepak Orang of Longsall Series Line, died on account of injury caused by sharp weapon. Accordingly, the OC Dumduma PS lost the GD entry so-and-so dated 27/2/19 and entrusted me for investigation. Exhibit 10 is the extract copy of the said GD entry. 10(1) is my signature. 10(1) is the signature of Otul Hazarika, who was the then in charge of Dumduma PS, and I am acquainted with his signature. Hence, I, along with my staff, went to Longsall Hospital. I saw the dead body of the woman at the hospital gate shown by nurse and doctor. I noticed a cut injury on the upper side of the neck of the dead body. The clothes of dead women was stained with blood. I met Kiran Tansorua, Wilson Means, and Ganesh Bhumis near the dead body of the woman who belong to the same line of the woman. From them, I came to know that the husband of the said woman, Sri Deepak Orang, caused cut injury to his wife victim. I found Deepak Orang present in the hospital. Hence, I took the custody of Deepak Orang. I record the statements. The statements of the witnesses, namely Kiran Tansorua, Wulton Mills, and Ganesh Bhumis, including Dr. Nirman Gogoi of the said hospital. From the hospital, I went to the house of the deceased along with the accused and other witnesses. I visited the place of occurrence, which is the house of the accused Deepak Orang. I entered into the house of the accused and found 4 rooms inside. I put on the electric light inside the house. Out of 4 rooms, 1 small room was used for kitchen. The house was built by bamboo and CI. I saw one showcase and with an Elena with TV at the first room of the house. In the middle room, I found 2 beds having mosquitoes net open and the bed. In the 3rd room, I saw some household belongings were kept. I found blood-stained blanket near at the threshold of the 2nd room. After removing the blood-stained blanket, I found 1 gunny bag which was also stained with blood. I found some human hair near the jute bag. I also collected some blood-stained soil from the floor of the place of occurrence. Thereafter, I seized the blood-stained blanket, gunny bag, some hair, and blood-stained soil in presence of witnesses, namely Ganesh Bhumis, Kiran Tansorua, Samu Pator, and Bodhu Orang, white, MR number 11/19. Exhibit 2 pertains to MR number so and so. Exhibit 2.4 is my signature. I recorded the statement of all witnesses. At that time, the accused was present with me at the place of occurrence. On interrogation, the accused brought out the offending dhow from the hiding place at the kitchen. I seized the dhow with MR number 12/19. In the presence of witness, white exhibit 4 and exhibit 4.3 is my signature. Since it was late night, I returned to Longswell Hospital from the place of occurrence. I brought the dead body of the deceased to the police station along with the accused. Other persons also came to the police station. I saw that the T-shirt worn by the accused contained with suspected blood stains. I seized the T-shirt of the accused in presence of Sanjay Bhumis and Mridul Orang, white MR number 13/19. Exhibit A is the scissor list. And 3.3 is my signature. 8.3 is my signature. On next day morning, I called upon the circle officer, Dumduma Revenue Circle, for the purpose of inquest on the dead body. After his arrival, the inquest was conducted upon and dead body in presence of witnesses. The dead body contains a red color blouse containing blood stains and 1 sky blue color petticoat containing blood marks. I seized the said wearing apparels in the presence of Kiran Tansorua, Ganesh Bhumis, and Ripan Orang, white MR number 14/19. Exhibit 3 pertains to the said MR and Exhibit 3.4 is my signature. Material Exhibit 1 is the printed blanket. Material Exhibit 2 is the gunny bag. Material Exhibit 3 is some black hair of the deceased and Material Exhibit 4 is blood stains. Material Exhibit 5 is the dhow. Material Exhibit 6 is the pink color T-shirt. Material Exhibit 7 is the red printed blouse. material exhibit 8 is the blue color petticoat. The above materials have been seized by me and I can identify the same. Thereafter, the dead body of the deceased was sent to postmortem examination. On 28/2/19, the father of the deceased, Naro Orang, filed the Azahar before the Dumduma police station, and OC Dumduma PS registered the PS case after receiving the FIR, being Dumduma PS case number 57/2019, and entrusted me with the investigation of the case. Exhibit 1-2 is my endorsement with the signature of then OC Otul Hazarika, which I know. Accordingly, I examined the complainant Naro Orang along with witnesses, namely Triple Orang. Thereafter, I again visited the place of occurrence and drew its case map by Exhibit 11, and Exhibit 11-1 is my signature. At the place of occurrence, I recorded the statements of witnesses, namely Amir Orang and Samir Orang. Both are sons of the accused Deepak Orang. Gita Orang, Bogi Orang, and Budhu Orang. From the statements of the above witnesses, I came to know that Samir Orang and Amir Orang saw the occurrence. Thereafter, I returned to police station after making requisition for recording the statement of the witnesses under Section 164 CRPC. I also recorded the statement of the accused. I arrested the accused and forwarded him to judicial custody on 1/3/2019. I brought the witnesses, namely Amir Orang and Samir Orang, to the court for recording their statements under Section 164 CRPC. On 16/3/2019, I sent a Dow pink color t-shirt, one red blouse and blue color petticoat to the Superintendent of Police office for the purpose of sending the same for FSL examination. Material Exhibit 11 is the copy of the prayer to the Director of FSL for examination of Exhibit A, B, and C, which was sent by the Office of SP Tinsukia. I received the copy of the said report on 14/6/2019. Material Exhibit 9 is the report, and Exhibit A, B, and C. Exhibit 3 is the forwarding of the said report by the Director of Chemical Examination, Guwahati. During the investigation, I collected the postmortem report. After receipt of the FSL report, I filed a charge sheet against the accused. Exhibit 12 is the charge sheet, and Exhibit 12-1 is my signature. On 27/2/2019, I was on probation duty and my service was not confirmed. The probationer officer is required to visit the place of occurrence with a senior officer. Probation officers are required to assist the investigation. SI Otul Hazarika, the then OC Dumduma, accompanied me to the place of occurrence. I did not record the statement of SI Otul Hazarika in course of my investigation of this case. As per Exhibit 3, MR 14/19, the red printed blouse suspected to have blood stains and one light sky blue color petticoat were suspected to have blood stains were seized at about 9:05 AM of 28/2/2019 at Dumduma PS. After affecting the seizure of the said materials, I put the said articles in the Malkhana, and said articles were marked as Malkhana number 49/2019. However, the said MR where the signature of cesium is found is written as MR number 14/19. None of the MR numbers bear signature of the witnesses and mine. I sent UBC number 619 of Sri Madhav Datta for postmortem of the dead body of the deceased at about 11 AM. The postmortem was conducted at 3:15 PM as per Exhibit 9. At the time of examination of the dead body, the deceased was wearing red blouse, sky blue petticoat of red check mekhela. It is not a fact that I prepared a false scissor list white MR number 14/19. On 27 to 19, the accused was in my custody. Since 9:05 a.m., MR number 11, 13, and 14 of 2019 does not contain any signature of the accused.
The full stop is not there.
Not
Full
there.
stop
my
is, it was in my custody
since 9 p.m.
since that ends, then.
Then MR number 19, 11, 14 of 2019 does not contain the signature of the accused. This is the second line. On 27 to 2019, I did not find the witnesses Samir and Amir, the sons of the accused, at the place of occurrence. Except PW5 and PW6, the other witnesses of the case are hearsay witnesses of the occurrence. None of the hearsay witnesses gave any statement that their source of information was PW5 and PW6. None of the witnesses examined by me on 27 to 2019, that is, on my first visit to the place of occurrence, stated before me that the accused caused cut injury to his wife after entering into domestic quarrel. On 28 to 2019, when I visited the place of occurrence, it was at about 3:05 p.m. At that time, the then OC, Atul Hazarika, was with me, but it is not mentioned in the CD. And that the OC concerned accompanied me to the PO. In Exhibit 10, A is pointed as the place of occurrence, which is the second room of the house of the accused, and B is pointed as first room of the house, and C is third room, and D is the kitchen. Room number A and room number B are interconnected, and there is a door where the incident occurred. There is no door shown in the room number C and D. There is not mention in the CD as to who has told me regarding the description of rooms of the house. At that time, the case was already registered. The complainant Naro Orang lives at Bordubi. There is no endorsement in the CD as to who informed the incident to Naro Orang. In the Azahar, it is not mentioned that who told Naro Orang about the domestic quarrel took place between the accused and the victim. The entire investigation of the case was completed by me within 3 days, except collection of serological report and postmortem report. I have not investigated the fact that whether the TV is the first room was in running condition or not. As per version of the accused, the local public initially took the victim to the hospital and he visited the hospital later on. I found the accused present near the dead body of the deceased at the hospital. There is no endorsement in the CD that interrogated the accused in hospital where the dead body of the deceased was kept. I recorded the statement of the accused after registration of the case on 28 to 2019 in the second half. There is no endorsement in the CD that I put question to ascertain the competency of PW6 Samir Orang before recording his statement. There is no endorsement in the CD who brought Amir Orang and Samir Orang to the police station before sending them to the court to record their statements, but relatives of the said witnesses brought them. Wilson Means took the custody of the said two witnesses after recording their statements. There is no endorsement in the CD that I have investigated to ensure whether the accused was present at the place of occurrence on 27 to 2019 on my first visit to the place of occurrence. It is not a fact that PW5 and PW6 are tutored witnesses. It is not a fact that the domestic quarrels so mentioned in the Azahar is not true. I have not obtained any fingerprint from the offending dog to ascertain if there is any fingerprint of the accused left thereon. I have not investigated to find out what is the blood group of the deceased. It is not a fact that exhibits so produced by me in the court are not admissible in law. It is not a fact that I have not properly investigated the case. This part of this evidence, my lord, regarding examination of fingerprint and blood group, my lord, it is very much evident from the FSL report, which is placed at page 120, my lord. 120, 121, 122. Material exhibit 9, my lord, is the report of the scientific officer, director of forensic science, my lord. That first one is down, raised by the IO, my lord.
Page, you are.
Page 120,
One-
exhibit 9, my material exhibit number 9.
Yes, please read.
1 to 4 are the bloodstain articles, my lord, that has been that have been staged, my lord. Result of examination, my lord, by mentioning that FSL marking, my lord, A, B, serological A, B, C, and D gave positive test for human blood of group A.
Yes.
That whether the deceased having the same group of blood is not, that is not evident from any of the evidences, my lord. The second thing is that fingerprint, my lord, that the murder weapon, that is also not for FSL for examination, my lord. Next one is page 43, 313 statement, my lord. First question, answer is 44. Page 44, my lord. Question 1 is PW Naro Orang deposed that this is woman so and so was given in marriage to you, and fateful day someone informed him that you killed his you killed her, said daughter. Yes, his daughter, his said daughter, and saw cut injuries on the neck of the deceased daughter at the hospital, and so he filed the Azahar by exhibit 1. What is yours say to the above?
No, he has negated.
Negated, my lord. Is the wife lying down? And so far as his explanation is concerned, he did not deduce any explanation, ma'am. Question 16, do you have anything to say? And do you want to adduce evidence in your defense? Answer is no,
Not necessary.
not necessary. And in judgment, my lord, was delivered at 15/12/2001, page 52 onwards. Reasoning part, lordship may find, and paragraph 42 onwards.
What does it say? See, madam, had it been a case of circumstantial evidence,
Yes,
then the aspect, significance of having the serological test done, FSL done,
yes.
would have been much more. Now, here is a case where there is not
Direct evidence is there.
evidence.
And
who's the-
medical evidence also
And
supported.
who is the witness? Witness is the own son
Yes,
of the deceased as well as the appellant.
yes.
The, the questions which have been put to him, and
That-
doesn't appear that he had any, what he had spoken was, had, it was the, all the facts which we had seen.
Yes.
Is there anything to disbelieve him?
No, my lord, I am not I have not make any submission regarding disbelieveness, my lord. But in para 46, Planet Fort below has stated that intentionally he has killed, my lord. But that liquor the accused was under the influence of liquor, that
Is that
part
an
was
exception?
negated.
That is not a general exception. Anyone can have liquor and cause a, commit an offense.
Otherwise,
Would it
this,
be
this
excused?
is a having the direct evidence case, my lord, so that cannot be, my lord. So far as the terms of punishment is concerned, it is 12 months for life, my lord. If that will taken the liquor part, my lord,
Liquor part is no excuse. So is the provisions of law. Come to
Uh,
general exceptions.
and on
Chapter,
for
chapter
which that,
said-
my lord, 300, exception 4, my lord.
No, that's not a general exception. That is only
Yeah.
converting.
Yes,
Conversion is the culpable homicide not amounting to murder. You're on that part. But even under that, will it come? Just have a look.
no, that provocation, I just want to indicate that provocation part, after the
Provocation-
hard word, that quarrel take place, my lord. So that the cut injury is there, it might not be intentional, my lord. So in the under influence of liquor, he committed the offense, my lord. And in that matter, lordship, I pray to for his
That will not.
lesser years of punishment, my lord, instead of life. Section 300, explanation 4, I would like to please.
Just a minute, please. Section
300, explanation number 4, my lord. Illustration part.
yes.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon sudden quarrel and without the offenders having taken undue advantage or acted in a cruel or unusual manner. Though it's a vital blow to
So,
homicidal in nature, my lord,
a sudden fight.
his
In the heat
conduct
of
itself
passion.
shows that he accompanied the dead body to the
Sudden-
hospital also, my. So that intention part I did not find. So in that case, lordship may reduce his terms of sentence, my. As there is a quarrel, it is evident from the eyewitness, my lord.
How has this exception 4 been explained? Case laws.
Yes, so, my lord.
Okay, we'll come back.
My-
Mr. Pathak, I think this will continue for some time.
I requested one of my colleagues to,
Okay,
but it's called out.
okay.
I don't find direct evidence, my.
Direct evidence,
Direct in the sense of general
Direct se-
exception, I don't find. I have searched,
case
but
law.
case law, in respect of case law.
What are you
Because
saying?
for some, by incorporate sector explanation 4, there must be some
Exception, not
pre-incident.
explanation, exception.
Exception, sorry. There must be some pre-act in all of the judgments this night. I have seen 2, 3, but generally it cannot be said that only because of consuming liquor that comes under. But so far as my lord, I pray for lilies in the ground that from 2019, date of judgment, the man is behind the bar mat. So if it is for life, that can be reduced to an extent, my lord. He has already passed 4 years, my.
That is on the, that is on the sentencing part.
On sentence,
Uh,
my lord, because
On the culpability, what do you say?
it is very much proved from the direct evidence, my lord. That cannot be, no explanation or no defense witness has already been there, my. So I have to go by the evidence of PW5, my. And doctor's evidence, medical evidence supported that eyewitnesses case. So that homicidal in nature, that cannot be denied. ma'am.
See, you have read the evidence of the two sons.
Yes, my lord.
Two sons have
5 and
deposed as 5 and
6, my lord.
6.
6.
6 did not see the incident.
My lord.
5 saw the incident. He is an eyewitness.
He is an eyewitness.
Come to page 15 again.
My lord.
He is, who is he? Amir.
Amir Oram,
Amir is 15. What is his age?
15 years.
Kindly turn over to page 17.
My lord.
Samir.
Yes.
What is his age?
12 years.
Now, what are the questions? At page 17. The witness is a tender, aged boy, and as such, to ascertain his competency, he is
Yeah.
asked the following question.
Yes.
Was such a procedure adopted for PW5?
That part is not.
Why haven't you taken up this point? You have not noticed.
Yes.
How do you differentiate between a 15-year-old, 12-year-old,
Yes,
12-year-old?
both are minor.
He is tender and 15 is not tender. Minor is a minor.
Minor is a minor.
And he's a child witness rather. 15-year. What was any satisfaction recorded that he appeared to be matured or to?
No, my lord. In 164 also, that
And-
part is not there.
And PW15 is the crucial witness. PW5, the
Yes,
child,
yes.
the eyewitness.
He is only the present who have seen the.
No, we are not saying that this should be a fatal thing, but
Right.
at least some kind of satisfaction should have been done, should have been arrived at.
Yes, yes. I missed that part. This is below 50.
And so far as the mother wanted to go out, open a door and go out, at that moment she was hacked.
Yes.
Now come to page 16. Cross-examination, second paragraph. My mother
Fell down.
fell down on the front door. Okay, there are 4 rooms of our house and she was lying there under injured condition.
Yes.
Then it is a fact that I had stated before the police earlier that on the back side of the door of our house, mother was lying. Do you have a sketch map?
That map is at page. 112, my
112. Yes. Indicates room of occurrence took place. Yeah.
place of occurrence that indicate at A, my lord,
A.
that middle room,
Hmm.
second room, my lord.
The houses H are on the back side of the house of the accused or front side. Now there is an indication,
It ought to have been backside, my lord.
but there is an indication by the arrow near H, as if this is the entrance.
Because in one of the evidence, they said that backside there is no road, front side there is a road. If road is not
No, this
in,
is not indicated as the road.
no, my lord, nowhere,
The
either of the front side or in the back side.
Road can be on each side also. Near the H, you see there's an arrow,
Yes, my lord.
as if it is the entrance to the compound. Now houses H, two houses are at H. On the left, E is the house of Gulshan, means younger brother
Elder brother.
of the accused, Gulshan.
Yes, my
The indication on the left side is not a road, though it looks like a road. They have not indicated to be a road. May not be a road.
only front side there. I said that there is a road.
স্কেচম্যাপগুলো বড় পারফেক্টলি করে আর স্কেচম্যাপের বিশেষকৈ কিছুমানত ডিষ্টেঞ্চটো মেক্স আ ভেৰি ক্ৰুচিয়েল ডিফাৰেঞ্চ নকৰে কিন্তু around about 100 feet or 100 meters নকৰে এইটো nothing এতিয়া আমি গমেই পোৱা নাই কোনটো এইটো ঘৰটো পিছফালে আছে নে আগফালে আছে চিম্পলি বিকজ নৰ্থ চাউথ ইষ্ট ৱেষ্ট ক'লেতো নহ'ব ন এইটো কিন্তু এটা এন্ট্ৰেঞ্চ এটা দিছে ৰাইট কৰি এইচৰ তলত arrow এটা দিছে নহয় as if this is the entrance কিন্তু ইহঁতে বেক চাইডত কোৱা বুলি কৈছে যেন পাইছো ফাদাৰে
IO has stated in page 34, my lord, he is mentioning about that 4 rooms. One is the kitchen, others are
You read 80, section 85, section 85 of the IPC. And 86. Please read.
act of a person incapable of judgment by reason of
Reason of
reason of
intoxication
intoxication caused against his will. Nothing in is an offense which is done by the person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act or that he is doing what is earlier either wrong or contrary to law,
provided.
provided that the thing which intoxicated him was administered to him without his knowledge or against his will.
Read 86.
Offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense, unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will.
See, these are the only two sections. You were intoxicated, then you say that I did not know, not will not help.
I have seen it, but there is no text. He himself consumed the liquor.
Voluntary drunkenness is no excuse for commission of an
Definitely.
offense. So you're in the aspect of the exception, number 4.
Number
Table.
In page 102, my lord, 164 statement of PW 7, 6, my lord.
Yes.
He stated two things, my lord. First, as in page 102, my lord, regarding quarrel, third line, fourth line, my lord. Before the quarrel, my father went to sleep and my mother scolded him badly. Thereafter, when my mother went to sleep, the quarrel broke out again and a fight ensued. Later, my mother went to open the door, and before she could open it, my father hacked at the neck of my mother with a dao from behind, and my mother fell down. So, first time that quarrel took place, person went to sleep, my lord. Thereafter, again that quarrel started when this disease followed again him, my lord. So, had it been his intention prior, my lord, in first quarrel, when the first quarrel took place, he ought to have been done. But for the second time, when he went to sleep, then that scolding part again started, my lord. So, earlier, there, from his conduct, and he also accompanied the deceased to the hospital, my lord. So, there might not be his premeditation, my lord.
You have not found a case, we have found a case for you. It it is also a quarrel between a wife and husband. Just read this. Exactly on the point of premeditation. Mr. Das, you have this thing? Can you find this out in your mobile or something? Madam, you have that?
Yeah.
Yes,
AR 72.
noting the fact.
Take out the AR 2011 Supreme Court, 3172, AR. বহুত ডিপ্ৰেছন নাই কিন্তু একদম এক্সেপশ্যনটো থাকে এক্সেপশ্যন 4 ইলাবৰেট নাই কিন্তু মানে হেৰি আৰু ৱাইফ এণ্ড হাজবেণ্ড ইনফেক্ট এইটোতো আৰু চিৰিয়াছ আছে অফেন্সটো পেৰেশ্যন দি পেলাই জ্বলাই দিয়ে ইয়াতেতো বাৰু ইয়াৰ নামদাৰ মানে মেনত হেভ দি ইণ্টেনশ্যন টু কিল হয় এইটো জ্বলাই দিয়ে মানেতো মিনাছ he threw water pot and thereafter a kerosene lamp fired. Kerosene kerosene lamp to mine. What the water pot to the burning simply more out of fact that unfortunately at that time lady was wearing an island saree.
Okay.
Better two to corruption exact man and it will be so. Even in this case, which we have referred, he came home in a drunken state, started quarreling. Then he threw a water pot. Then thereafter he threw a kerosene lamp. And she was wearing a nylon sari.
It was converted. It was not
Just converted.
converted.
But here with a dao hacking on the neck. Oh, he does repair. Yeah, to hospital, we say. Any more? What is the sentence given, life?
Life, my lord. Life and fine.
What are the, punishment prescribed?
Imprisonment for RI, reverse
No,
imprisonment.
under section 302.
Life and
And if it is converted, what are the punishments prescribed?
either it is
304?
304 part 1 or part,
Now, what are the punishments prescribed?
in part 1, my
May
lord,
extend to 10 years, may extend,
may extend to 10 years.
and may also. Ten, which may extend to 10 years. He is in,
28 to 2019. He was arrested, my lord, very next day.
and he was on bail.
I think no, my lord. Because this judgment. Perhaps not, my lord, because in earlier statement, it is not there. Ayub has himself stated that he arrested very next day, my lord. One thing, my lord, in judgment that victim compensation is not provided, my lord. Both are minor sons, my lord. That part I did not find in the judgment, it's 357A.
এইটোতো সেই child কেইটা victim হ'ব নেকি? হ'ব? Dependence. Okay. Do you have a copy of the scheme? Under 357A?
Soft copy I have.
Network আছে তো?
Initial scheme is 12, my lord, and 19 some compensation amount has been enhanced.
তোমার ওয়াইফাই দিয়ে যদি খুলিব নোৱাৰে একো লগ নহয় সেটা 768 ডিপেন্ডেন্সত আহি যাব victim storage dependence victim falls আচলতে বাচ্চা কথা নহয় they are the dependents of the victim upon whom the offense has been committed he or she will be the victim এতিয়া না এইখানে এটা rightly for dependent was to vote to use process মেইন পাৰপাছটো এইটো আমাৰ হৈছিলে মেইনলি ধৰক এই এচিড এটেক ৰিলেটেড বিলাকত যে আছিলে সেইবিলাকৰ কাৰণে অনা হৈছিল এতিয়া মাৰ্ডাৰ ভিক্টিম এটাটো তেতিয়া এটা কোনে পাব তেওঁ যদি আছিলে কোনোবা ডিপেণ্ডেণ্ট Yes, that's all. Yes.
So if we look into the whole evidence lordship, apart from the eyewitness lord, PW5, there are other circumstances are also there, Lord. It's just like that, the 3 persons are there, son, 2 sons, 1 daughter is there, Lordship, and husband and wife are there. And moreover, it is also proved that Lordship quarrel took place, some kind of quarrel, Lord. And moreover, injury is on the neck or just behind the neck, above the neck, Lord, that part. It is also there. And this raised hue and cry, that is gone by 2 and 3, the child make hue and cry, Lordship, after the incident took place. And Kolam Katari is also led by the accused, Lord, himself. So evidence that weapon, Lordship,
Yes.
it is shown by this
Where?
accused, Lord.
Where?
It is there, Lord. CW10 is here in page.
Ten is at page
Not,
24.
not, Lord. Give me 1 second, Lord. This one PW4, Lordship, page number 14, Lordship.
1-4.
1-4.
Yes.
PW4, Lordship. He is a Caesar witness, Lordship. The second line, the accused showed police a sharp weapon in the kitchen, Lordship. He showed. The sharp weapon was a column katari which contained blood stains, Lordship. So discovery of weapon is also there, Lordship.
Who is he?
He is Caesar witness, Lordship.
Kiran.
Moreover, in the IO.
Just a minute. Kiran.
Lord.
He's a chowkidar, I think. Now, chowkidar to asile. Hi. 9 chowkidar. Please read again this part,
Lordship, page 14.
14, from the first line. They also found strands of cat hair on the floor.
Lordship.
Then accused shown, first line itself.
Lordship, the accused showed police a sharp weapon in the kitchen, Lordship.
Yes,
The sharp weapon was a column cutlery which
yes,
contained blood stains, Lordship.
yes. Where is the seizure part?
The said sharp weapon was about 2 feet long.
Yes,
Police also seized one blouse and a petticoat, etc. as exhibit 4 other seizure list and so and so, Lordship, are my signature,
now where is the statement regarding seizing of the Kalam Katari?
Lordship. Lordship, in page 35, this is the IO interrogation, IO, Lordship, evidence, deposition, Lordship, page 35.
Yes,
Lordship, it is stated in the second paragraph, Lordship, I recorded, Lordship, got
second paragraph.
Lordship, second paragraph, I recorded, may I read, Lordship?
Yes, yes.
I recorded the statement of all witnesses at the time. At that time, the accused was present with me at the place of occurrence. On interrogation, the accused brought out the offending dhow from the hiding place at the kitchen, Lordship. I seized the said dhow, 5 MR number 12/2019 in the presence of the witnesses. 5 Exhibit 4 and Exhibit 4.3 is my signature. Lordship. In page 91 is the seizure list.
See, there are 3 seizures made.
Good.
Why in the same place of occurrence? Had it been some different locations, one would have understood.
Good.
He comes to the house on the date of the incident based on the telephonic call made by the doctor. Those are corroborating. Kiran said to the doctor, make a call.
Good.
Doctor made a call to the police. Police went to the hospital. Thereafter, at 11:50, before midnight, on the date of the occurrence, they come to the house of the appellant. Come to page 86. 86.
Good.
Date and time of seizure,
Good.
27/2/2019.
Good.
And the FIR has been lodged on 28/2/2019, the next date.
Yes.
But since doctor had informed the police, police had come, no problem with that. See the descriptions of the, see the place of the seizure, Place of occurrence, that is the house of Deepak Oram, correct?
Correct.
Now, description. One, black printed blanket, so-and-so gunny bag, black hair, blood stains should be from the floor.
Correct.
There is no other scissor.
No, Lord.
Come to the next at page 89.
Correct.
Another scissor.
Lordship.
This is the next morning at 9:05.
Correct.
28:09. He seizes one red printed blouse and one so-and-so, okay?
Lordship.
And in the earlier also at Caesar 87, Kiran is one of the witness
Lord.
at number 2, and here Kiran is the sole witness.
Lord.
Or,
Repeat full
no,
page
there are witnesses. He's the first witness. And come to page 91.
Lordship.
See the time. 28 to 19 at 12:50 p.m.
Lord.
Where? Place of occurrence.
Good.
Here, for the first time, one sharp pruning dowel with wooden handle. Forepart of the dowel is curved. Length of the dowel is 2 feet. Stains similar to blood stains are seen on the dowel. Weight of the dowel is ounce.
If we look into the FSL also, Lordship, the same kind of blood group is there. Group A.
Who's this group A?
Lordship, it is not here, Lordship.
How do you know the group A is of the deceased? In the PM, is there any reference to blood group?
No, Lord.
evidence laid.
It is 2 feet long, Lord, Patadi. And weight is also 300 grams. It's not a small one. Lord.
এটা কি আপনি conceal বলে লিখেছে দেখছেন পেজ 91 আর মানে 27 to আনিব কারণে led by the alleged person which was kept concealed by the alleged person in their kitchen room. এটা প্লেস অফ অকারেন্সত গৈছে ব্লাড ষ্টেইন পাইছে আৰু কি ইনভেষ্টিগেশ্যন কৰে যদি বিচাৰিয়ে নাপালে মস্ত দাও এখন ঘৰৰ ভিতৰত এনেকুৱা নহ'ব জংঘলত সোমাই থৈ দিছে পাকঘৰত পাইছে বুলি কৈছে আৰু তাক হেৰি বেম্বু হাউচ উইথ টিন শ্বীট সৰুকেইটা টিন শ্বীট বস্তু থাকে তাতে একো নাই বস্তু বেছি ভাল কৰিব গৈ ইনভেষ্টিগেশ্যন দেখুৱাব যায় এইবিলাক প্ৰব্লেম কৰে মই পাহৰিলে কৰিব পিছত এইখন আৰু বনাই আনিম ৰাতি পাব লাগিছিলে ৰাতি গৈছে বিচাৰা নাই নেক্সট ৰাতিপুৱা গৈছে 9 বজাত কাপোৰ কানি আনিছিলে এইখনে বিচাৰি নাপালো কিহেৰে মাৰিছে ফাৰ্ষ্টটো আহিব কিহেৰে মাৰিছে Yes.
Moreover, Lordship, it is in the hiding at the kitchen, Lordship. It is hiding, Lordship.
No, he there in the Caesar list there is he makes a statement it was concealed in the kitchen room.
Lordship.
Have you seen the description of the house?
There is
What is the house?
Lordship, it is sketch map is there, Lordship.
No, not sketch map. House was made of what? Bamboo and
Lord,
tin.
Lord.
It is not a house where you can conceal a lot of things. It's a hut kind of a thing. He goes there at night. Okay, night, give him the benefit of doubt. Even you cannot give him. He goes for an investigation. At least first thing we'll see whether the weapon is there or not. No mention. He goes there at 9 o'clock in the morning. No, not even an utterance. And again at 12:50 in the afternoon, he goes and seizes the dhow. He says it was concealed in the kitchen. Who has stated about the presence of the appellant in the hospital?
I think.
Page 24, CW10. Conduct. Please give this by 2020. I was 20.
Page
Page 20,
24.
25. 24 is chief and in cross he was. Page 25. Next.
Yes. Which one? 25, what is it?
The injured was accompanied to the hospital.
By many person, yes.
Next slide. After
Yes.
comma, but I could recognize on some means and type.
Moreover, the incident took place within the four corners of the house, but he could not explain in 313. Apart from there is eyewitness there, Lordship, but 106 will also come, Lordship. And his presence is also not denied. In any of the witnesses has not been cross-examined on that point, Lord.
Huh?
Any of the witnesses, Lordship, has not been questioned that he is not present or it is not here, Lord. He is present, Lord. And in 313 also, he has not stated that he was not present, Lord. So 106 will also come, Lord. In my humble submission, Lord.
What about the exception 4?
But if it is stated that, Lordship, in a sudden fight, but the provocation has to be taken into account, Lordship. What kind of provocation? If we look into the statement of 164, Lordship, of the.
No, there is no question of provocation here.
Lord-
Provocation is the first exception.
Lordship,
We are on the fourth exception.
Lord,
Please read four.
certain fight is there, Lord. But the culpable homicide is not murder if it is committed without premeditation in a certain fight, in the heat of passion, upon a sudden quarrel, and without the offenders having taken undue advantage or acted in a cruel or unusual manner, Lordship. In the first, Lordship, before there is a sudden fight, Lordship.
First,
Upon a
it has to be
quarrel,
without
fight
any
is-
premeditation, that there was no, nothing in the mind of the accused that, oh, it's a pre-planned or there is a, it just spontaneously, there was a sudden, there was a fight.
Lordship,
And therefore, sudden word has been used twice.
Lordship,
Sudden fight,
and
sudden
sudden
quarrel.
quarrel, Lord.
Why wasn't it a sudden fight or sudden quarrel?
Good.
Learned Amicus is trying to bring in a case to fall under the exception of 4.
But
If you are refuting that submission, you have to make out a case that there was no sudden fight or there was no sudden quarrel.
there's, Lordship, if we look into the 164, yes, a fight is there, Lord. Some kind of quarrel is definitely there, Lord. Premeditation, Lordship, it cannot be said. It is he mediated, earlier he is making anything to murder or like that, Lordship. But the 2 feet long is, and on the back side, at the vital part, Lordship, I'm only on that part, Lordship. On the back side, from the back side, Lord. And that's on the vital part. And there, one word is there, Lordship, without offenders having taken undue advantage, Lordship. It is also clear that, Lordship, the explanation, it is immaterial which party offers the provocation or commits the first assault. But one thing is that without offenders having taken undue advantage, Lord, from the back side, Lord, and with the dowel, Lord, 2 feet long. Otherwise,
But
Lord, quarrel is there.
don't you think that the prosecution, apart from the eyewitness, should have made one attempt at least to connect the dhow with the appellant? One fingerprint,
Lordship.
he has seized the dhow, he did not take the fingerprints.
Moreover, blood sample of the deceased should also be taken, Lord, so that it matches with the deceased.
At least the blood should have matched with the blood samples collected at from the ground.
It's true, sir. It's true.
The serological test, 5 samples belong to human blood.
But-
That perhaps would not be enough
Okay.
normally.
But-
Here, of course, the eyewitness is there. Matter is slightly different. And that too, none but the sun.
Son, Lord. Eyewitness is also there, Lord. Otherwise, quarrel is there, Lord. Definitely. Fight is also there.
Anything else?
No.
Close to the door, আপনি কোন? Hmm? Quarrel relation after quarrel. Sudden fight, neglect of your profession, upon a sudden quarrel. That means fight, quarrel preceded fight. Upon a sudden quarrel. আগতে quarrel হল, তারপিছত out of heat of passion, there was a sudden fight. In that sudden fight, the assault was. Yeah, correct. এগুলো থেকে গ্রুপ ক্লাস যে হয় কিভাবে মারামারি হবে মারামারি দুইটাই মারামারি করছে মারামারি করছে এখানে একটু বারে বারে করেছে it is immaterial in such cases which party offers the provocation or commits the first assault ওকে প্রথমত মারাতেও মরে যাবে এই হেৰি কৰিছিলো এম বৰ্মন কে দাস okay so concluding the $19 jail appeal RD भैया कौन আসেনি আরডি ভিউ কোন আছে এটা? মিস আরডি ভিউ মিস আরডি ভিউ ভিউ পারমানেন্ট none appears for the appellant in spite of appellant on call in spite of name of the learned amicus curiae being reflected in the cause list. Full stop. Sri K. Das, learned APP is however present. Para. In the interest of justice, matter is adjourned to be listed after a week. Para. No, full stop. It is made clear that in the event the learned amicus, the appointed amicus curiae is absent on the next date, comma, this court would be constrained. This court would appoint another amicus curiae for his, another amicus curiae for the appellant. Item 20. কোনো নাই? Same order. খালি লাস্ট লাইনটো নালাগে লিখিব এইটো জেল এপিল নহয় যে এইটো হেৰি লাস্ট লাইনটো নালাগে হ্যাঁ আমার কাছে কথা নালাগে বুঝলি কে দাস করবেন নেক্সট উইক মোৰ সিঙ্গেল বেঞ্চ এখন আছে আছে না হেৰি সিঙ্গেল বেঞ্চৰ মানুহ কৰিব মই আহি যাম 5 minutes
Yeah, please, Lord. Lordship may take up item number 2. One of the petitioners, there were 2 petitioners when the petition was filed, but later on, petitioner number 2 in both the writ petitions, he has withdrawn. And there is a specific order to that effect in both the writ.
Ahmed is appearing for whom?
The private respondent.
And Mr. Mohanto?
College.
College. And you are for the department. What is the matter about?
My lord, I'm challenging the selection to the grade 4 post, to which I was also a candidate, that there was no
Notices have been
issued. They have filed their
Okay,
AO.
okay.
So
Can it be heard?
It can be heard.
Can be heard. What is the next item? Review? Okay. What is it, reviewer?
Praying for some modification, and as understood, my lord, and understood by the petitioner, some ambiguity, my lord, whether that relief is granted to the particular 2 petitioners or the entire petitioner. There is 10 petitioner here. That earlier one, another case was that here was 2 petitioners. That last line, my lord, that lordship take.
But this will wait for your turn. Let's see. Yes, Mr. Prasad.
Although the petitioner, the writ petitioner was appointed, petitioner number 1, he was appointed on temporary basis,
There were initially two petitioners.
initially 2 petitioners,
Number two has
has
withdrawn.
withdrawn from both the writ petitions. In item number 1, by the order dated 5/6/2023, he has withdrawn
5/6/2023 in WPC
in
153.
153. And there is another order in item number 2, 26/5/2023.
Same.
Same.
26/5/23.
2023. Writ petitioner number 2 has withdrawn
3029.
3029.
Withdrawn.
Withdrawn.
What is the cause of action?
My lord, we are challenging the selection process that while selecting, no guidelines were framed.
Selection for the post of
Grade 4. There were 7 posts of grade 4 employees
where?
in BN College, Dhubri,
In a particular college.
in a particular
BN college.
BN College, Bholanath College, Dhubri. If your lordship will turn to page 25 in Active 5,
Yes.
it is the advertisement, my lord. Page 25 and
We are
Active
taking
5,
3029.
302,
Page 25.
page 25.
Yes.
This is the advertisement, my lord. Advertisement for grade 3 post as well as grade 4 post.
We are in
Concerned
grade
with grade
4.
4, grade 4.
Grade 4. This is page 25 is advertisement. Date of the advertisement?
22nd
November.
November 2022.
Okay. Yes.
So it is pursuant to DHE letter dated so and so, 25th April
You did not
2020,
read the whole.
because they are relying on these 2 guidelines,
Okay. Okay.
These
Okay.
two.
Okay.
25/4/2022
Right.
and so and so dated 28th July 2022.
Yes.
Applications are invited.
Okay.
Somewhere in between, my lord, B, grade 4,
Yes.
there are total 7 posts,
Yes. 7 numbers of posts. Right.
and these are reserved posts. 1 post is for PWD,
Yes.
persons with disability,
Yes.
3 posts for OBC.
Yes.
I was a candidate under OBC category, man.
Yes.
2 posts for EWS, economically weaker
Yes.
section, and 1 post for STP. Prior to that, my lord, annexure 1, I'd like to place page 21.
21. What is 21?
Annexure 1, page 21.
What is that?
My lord, I was temporarily appointed in the same school in grade 4 post, and I was working there since 1/12/2006.
Working.
Since 16 years.
Yes. Yes.
Then I'll place, my lord, page 26 and Annexure 6. This is the guidelines they say, the college say that they are following. The governing body of BN College Dhubri framed the following guidelines for selection of grade 3 and grade 4 staff in the college by adopting the government guidelines as per letter 25/4/2022 and letter number so and so 29/4/2017
Yes.
and 28 July 2020. I've taken out the guidelines separately, madam.
No, it's here. What is page 26 then?
Primarily, these guidelines talks about grade 3 posts, how they are to be appointed.
Hmm.
It doesn't talk about anything about grade 4 posts. madam.
These are the copies of those notifications.
Notification.
Okay.
Are given. madam.
Okay.
Only the relevant one is at page 10, the last page,
Yes.
which is for grade 4, is that all grade 4 posts except sweeper and mali class 8 pass. So it talks about the
educational qualification that is required for grade 4.
But this, the guidelines which have been mentioned are of 2017 and 2022. You are placing a guideline of 2009.
My lord, it talks about that also
Where?
because the prior page, my lord, just page 8
Of this compilation?
of the compilation, that is 28 July 2022.
Yes.
The last paragraph, in respect of provincialized college for selection of grade 4 post, notification dated 30th January 2009. Issued by the GAD department is hereby allowed to be followed. So the educational qualification is fixed now.
Yes.
Although the other notifications are there, it talks about grade 3 post, not about grade 4. Now, in the intervening period from 2006, when I was initially appointed, till this advertisement was issued, I was requesting the college to regularize me. The college assured me that, okay, whenever the regular selection is conducted, my case will be considered and I will be given some weightage for my past service.
Yes.
But when the selection process started, within a week, it was done. The written examination was conducted. The viva was called for without publishing the result of the written examination. And then
You
immediately
had participated in the
I
Viva?
participated in every,
Both?
both.
Okay.
Because whoever had appeared in the written examination, all those candidates were called for the viva.
Yes.
This viva concluded on 30th of December 2022. When I came to know that no weightage would be given, I immediately approached this honorable court by filing the item number 1, my lord, WPC 153 of 2020.
30th of December, what had happened?
30th of December, the viva concluded.
Okay.
When I could understand that no weightage would be given to me for my past services, I immediately approached this court.
Yes.
The selection process was not culminated. On 5th of January 2023, I filed writ petition 153 of 2023.
Yes.
It was taken up on 8th of January, 9th of January, my lord,
Mm.
and an order was passed by instructing the government advocate that do not finalize, will pass appropriate orders on 18/1.
Mm.
However, the case was not fixed on the next day.
Oh.
We had already informed the college on the third day that we have filed a writ petition. Please do not finalize the selection process.
Yes.
But in the meantime, in the month of May, we could come to know that the selection has been made and the director has issued appointment orders. And that's how we filed the second writ petition, 3029.
Appointments were made.
Appointments were made, and we challenged their appointment, the private respondent. Out of 7 posts, 5 persons were appointed. And their respondent number 5 to 9 in item number 2.
Okay.
The college authority has filed their AO stating that we have never promised or there is no rule or guidelines that weightage can be given. The director has filed his AO stating that we cannot regularize. He has completely stated something else. We are not asking for regularization. We are in the regular appointment. We are just seeking for some weightage for our past service. And to that regard, my lord, I am relying on two decisions.
Yes. Yes.
One is from 2017, volume 11 SCC, page 421, that is Sachivalaya Dainik Vetan Bhogi Karmachari.
What is the citation?
From, my lord, it is from Supreme today.
No, no, no. The
Supreme
other
today.
was
Citation is 2017, volume 11 SCC, page
17,
421.
11 SCC. 421.
421.
Okay, okay. That is there. Okay.
In this
Right.
case, these grade 4 employees, they were working, and there was an agreement between the employer and the employee that as and when the regular selection would be made, they would be given weightage,
Yes.
which was when they filed a writ petition for regularization, considering the agreement between the parties, the High Court allowed it. The division bench of the High Court said no, because of Uma Devi, this cannot be granted. However, when they went to Supreme Court, it was stated that Uma Devi has no application in this case, since there is already an agreement and it is not against the law. So they can be given some weightage.
Okay. Now, how does it help you?
That weightage can be given if it is not against the law.
No, what about the
Agreement part.
agreement part?
So there is no agreement between us, but there was verbal assurance given to me,
No, that is,
which
see,
has not been denied
see
in his
that,
AO.
no, they have said that that is denied. The college has denied.
They have denied that they have not given me an undertaking that it will be granted. They have not specifically denied what I have stated in my writ in paragraph 6.
Let us see.
In paragraph 6, page 10, my lord, of my writ.
Of the FNN opposition.
Of the writ petition, my lord. First, I'll paste my submission. Page 10, paragraph 6.
Yes.
The petitioners respectfully state that although the petitioner had appeared in the written test and the interview conducted by the respondent number 3 as stated above, as they had no option, they could learn that respondent number 3 and 4 had not at all considered the matter of providing any weightage to the petitioners who are serving in the college for last several years. The petitioner states that on several occasions, the petitioner had approached the college authorities to appoint them regularly, and the authorities had also assured them that regular selection would be initiated wherein due weightage will be given to them for their temporary service. But in the instant selection process, the respondent authorities, without framing any guidelines and without taking any decision for providing due weightage, had proceeded for selection, making them to compete with the fresh candidates like freshers and thereby depriving the petitioner from a fair consideration. To this, the respondent number 3 has replied, my lord. Page 53 is his AO. Paragraph 8, my lord, page 55.
Who is R3?
R3 is the principal of BN College.
Mr. Ahmed, your client. Oh, Mr. Mohanto.
Page 55, paragraph 8. Otherwise, the AO starts from page 53.
Which paragraph?
Paragraph 8, page 55.
Paragraph 8.
8. That with regard to the statements made in paragraph 6 of the writ, this deponent denies the same to be wholly correct. The deponent begs to state that while conducting the selection process, college authorities had adopted guidelines as per letter number 22, 25th April 2022, 29/4/2017, 28th July 2022, and 30th January 2009. as per GB resolution dated 1/12/2022. And in the advertisement dated so as well as guideline, it was nowhere mentioned that the petitioner's experience will be considered at the time of interview. The deponent further requested that no undertaking was given to the petitioners, that due weightage will be given to the petitioners at the time of regular hearing. Now, second decision, my lord, is Uma Devi. Uma Devi is a case of regularization, wherein the Supreme Court said there can be no regularization of illegally appointed or ad hoc appointed persons. However, while considering the case at paragraph 54, if I'm at paragraph 55, the Supreme Court says that if the appointments are irregular, not illegal, and they have contributed substantial amount of service, then while considering the case,
Paragraph?
paragraph 55, my lord,
Hmm.
last 10 lines,
Yes, please.
it says, if sanctioned posts are vacant, they are said to be vacant, the state will take immediate steps for filling those posts by a regular process of selection. But when regular recruitment is undertaken, the respondents in so-and-so and those in commercial tax department will be allowed to compete, waiving the age restriction imposed for the recruitment and giving some weightage for their having been engaged for the work in the department for a significant period of time. And that would be the extent of exercise of power by this court under Article 142 of the Constitution to do justice to them because of the past. Some weightage. They have not declared anything. They have not declared
142.
140. It's 140.
Last line is creating problem for you.
The plenary power of Supreme Court. "16 years I have given. They have still kept me in service. I am working there still temporarily. They have not given, they declared what are the marks obtained by the other candidates. I do not, they have not even disclosed before this court.
Marks not disclosed.
Not.
You are working under what capacity?
I was
No,
11.
no, no. Under strength of what?
Madam.
Under the strength of what you are working? Are you
Yes.
protected by an interim order?
No, no interest.
But how are you then continued?
They are asking me to work. I am working. They are giving me salary.
Even today?
Even today.
Is he working?
Till date, I don't know.
Let him confirm. Let him confirm.
No, no.
I am still working.
Not today. At least was he working? Because these matters are pending since quite some time.
For a blood second, this working.
No, no, not the earlier period. After this election,
After this election,
is he still working?
after this-
No, but he says that he's even getting salaries.
Shall I
That's
say
a-
temporary, Lord?
As a temporary,
They are
As a temporary.
Yes.
We are only asking whether he's working. That's the only question. Is he working? He's working. Mr. Ahmed,
But here I am appearing for respondent number 5678 private person.
you don't have much to say
Ye-
in the
yes,
decision-making
sir.
process.
I don't have.
You have
much to-
you have been duly selected. That
Yes,
is
sir.
your
I have
case.
been duly selected, appointed, I am working. I have, so far as the regularization part is concerned, Lordship,
Yes.
I'm no way connected with that, Lord. But one thing, Lordship, definitely I would like to point out before this honorable court. Here, Lordship, the advertisement was issued on 22nd/11/2022,
Here for our
R5 to R9,
advertisement is of
22nd/11/2022.
yes.
That advertisement, Lordship, just now my learned.
Yes, yes, I have seen that.
Yes, Lordship. Lordship has have already seen that.
Yes.
Lordship. Here, Lordship, that the date of submission of application was, Lordship, within 15 days.
Hmm.
It was published in the newspaper on 22nd of November.
Hmm.
So 15 days was there, Lordship. In the advertisement dated 22nd of November 2022, there was no provision for providing weightage to the petition.
Wedding?
Weightage,
Wait, no.
Lordship, on the basis of which, Lordship, the writ petition has been filed. Extra mark for the experience. That was not there in the advertisement. And Lordship, that advertisement was not challenged. Both the writ petitioners participated in the selection process. They appeared in the written interview. Thereafter, they participated in the viva voice also. And Lordship, now, Lordship, after that, Lordship, they have preferred both the secret. So, Lordship, one ground, Lordship, which I am taking is that, Lordship, once the candidate have participated in the selection process, that too in written and viva, thereafter challenging the selection process or advertising, that is my humble understanding. So far, my humble understanding is concerned, that is not wrong. I'm relying on 4 decisions, Lordship, in that regard.
Om Prakash, Madan Lal.
One is, Lordship, the state of Uttar Pradesh versus Karunesh Kumar and others. It's reported in Supreme Today.
Give the citations.
Yes, sir. I'm having the copy. Lordship.
You're not citing Madan Lal? JNK?
Paragraph 21, 22, and 23. Lordship.
Paragraph
21, 22, and 23.
21, 22, 23.
Another judgment, Lordship, 2018, 12.
Just a minute, let us have a look what has been stated here. 21. Estoppel, appropriate, reprobate.
Yes, sir.
Mr. Prasad is in quicksand. Slippery grounds. 2020. Last is 20.
3, Lordship.
23 also.
Yes, sir.
22, 23.
Another judgment,
Yes, which one?
2018, 12 STC, 635. No judgment, but 1 page judgment. Paragraph 6 and 7.
Karnati Ravi.
6 and 7.
7.
The next judgment lordship on which I am relying on lordship is 2023 4 GLT 160.
For GLT.
Yes, lordship. 2023 4 GLT 164. Paragraph number 33, lordship, primary.
Yes.
And lordship, the last-
33.
Yes, lordship, 33. And for the last judgment lordship, which I am referring to, lordship, 2018 14 SCC 129. Tania Malik versus Solicitor General of the High Court. Paragraph 20,
Paragraph
21. There is another judgment for High Court. Mirinal Bishop, Dr. Mirinal Bishop, State of Assam, 2019 486. Right. Paragraph 30.
paragraph
13 and 14 miles.
Yes.
Lordship, another point, Lordship. Here, Lordship, the petitioner was appointed by the principal. The petitioner was appointed by the principal of the court. The rule says, Lordship, the appointing authority is the director. And Lordship, the affidavit submitted by the director, Lordship, is very clear. My learned friend, for the clarification, will apprise this honorable court on that point.
The appointing authority is the director. And what is your second submission? What did you say?
The affidavit submitted by the director, Lordship.
Hmm.
Paragraph number 5 and 6, they have categorically stated that, Lord. There is one paragraph. Six, paragraph.
Okay, it's okay.
The deponent begs to state that since the petitioner was appointed by the college authority in non-existent post without prior approval of the government of Assam Higher Education Department, and there is no provision, guidance, etc. to regularize the service of teaching and non-teaching staff in provincialized colleges of state who are working against a non-sanctioned post. Therefore, the state government is not liable to appoint the petitioner against a valid sanctioned post in deviation of rules and regulations holding the field for appointment of non-teaching staff in the provincialized colleges. And Lordship, so far as the rule is concerned, Lordship, the Assam Employees Provincialization Rules 2010,
Assam?
Assam College Employees Provincialization Rules 2010. Rule 5,
Yes.
Rule 5 says mode of recruitment. The recruitment shall be made in the manner prescribed hereinafter. Page number 497. It-
496.
96 starts, Lordship. Rule 5 is 97.
Yes.
Mode of recruitment. The recruitment shall be made in the manner prescribed hereinafter. Lordship may kindly skip clause 1. This is related to principal section. Clause 2. For the post of lecturer, librarian, appointment shall be made by direct recruitment with prescribed qualifications through open advertisement into leading dailies, at least into consecutive issues. In respect of grade 3 and grade 4 posts, the list of candidates shall be collected from the local employment exchange / advertisement in the newspaper. Lordship, by way of an advertisement for the vacancies to advertise, we participate. And Lordship, thereafter, how to make the selections, year-wise vacancies is to be assessed, that is there in Rule 6. Who participated, and Lordship, we faced the written as well as viva voice, Lordship, and we were selected. Now, Lordship, appointment letters were issued in favor of us. Now we are talking.
Have your marks been disclosed?
Lordship, they have published the merit list, Lordship, and that merit list was forwarded to the director for a.
You have the copy of the merit list?
No, Lordship, I don't.
Is it on record?
The writ petitioner has Lordship at Annexure 12, Annex 1 list. That list of total number of approved cases for appointment of grade 4 in various provincialized colleges. Here, Lordship, our name is also there. This is, Lordship, for the entire Assam, for the entire.
The advertisement was for the entire state.
No, Lord.
Then
It was for the college.
it is
And
for
so far as
BN
the merit
College.
list is concerned, Lordship, my learned friend.
No, this selection was pertaining to a particular college, BN
Yes.
College.
Yes.
Now the select list was definitely, we presume that it was published. Do you have a copy of the select
No,
list?
I,
Okay. Mr. Mohanta College.
First, he was that some weightage was not given, Lordship. Weightage cannot be, I can prevent, Lordship, it is function of the director of higher education, Lordship. I am a principal, Lordship, was, my concern was to.
You are for the college.
For college. Lordship, to conduct the interview.
Respond number?
3.
Hmm.
To conduct the interview as per the guidelines submitted by the Lordship. Yes. The guideline, Lordship, the guideline was actually for gate 3 post, there was specific guideline, but not for gate 4, there was no specific guideline. But yeah, patient for that. But Lordship, one
Yes.
guideline has been given, Lordship, that this case that the JAD department guideline will be followed. JAD department guideline is a simple, Lordship, SLC, get for SLC, and Lordship college and the department authority may proceed.
Not HSLC, class 8
Lordship,
for grade 4,
for get for
class 8 passed.
class 8 pass, Lordship,
Guidelines of 2009.
2009, Lordship.
Yes.
Then Lordship college authority decided to hold 50 marks for the get for, Lordship, written test and according merit list was prepared, Lordship, and
No, class 8 that is not the subject matter
not
of
this subject
dispute.
matter, and Lordship,
He is not disqualified because of class 8 or
Not
he
yet.
had participated. He had
and the marks
participated.
is, he is not, mark, there is no question of marks, also he is not asking the marks, Lordship. But apparently, I have forwarded the entire interview list, Lordship, who has got the highest marks, Lordship. His only concern is that some weightage should be given to him. And Lordship has queried to that Lordship, yes, he is working, till that he is working, with a contextual basis. These are the regular posts. The contextual capacity he is working since he's playing.
Okay.
But for the regular post, Lordship, I have conducted the interview as per the governing body decision as DAT department, Lordship, and the merit list has been forwarded, Lordship.
You have a copy of the merit list.
Merit list has been today I have not.
At least what is the difference of the marks?
Yes.
See, rightly or wrongly, he's worked for around
Yes.
14, 15 years.
15 years.
Going strictly by Uma Devi, there is no concept of weightage.
Yes.
But at page 55, there is some observation.
Yes.
But those are under 142. Article 142.
Yes.
But even if you exercise powers under 226 plenary powers, but we'll have to first see whether the initial appointment was done in a regular manner. Initial appointment, you said it was not even by the appointing authority,
Not
not by the director, by the principal.
principal. For weightage,
Isn't
Lordship,
he?
is that guideline, the JAD guidelines. It was forwarded to me, Lordship.
Mr. Prasad has, I think, given to us.
JAD guidelines. 2009, no? That's nice.
Which page?
Last page, my lord, page 10, my.
No, which page are you relying upon, Mr. Mohanta?
Page. Yes.
Page 10.
Page 10.
No, there in the paper which was forwarded by Mr. Prasad, the minimum qualification was 8 passed.
8 pass.
Here it is HSLC.
That is for grade
No, grade
No,
4.
get 4.
grade 4 of Pandit Deendayal Upadhyay College.
No, in the 4th page given by, there are 2, yes, but that is not the, that is not the issue.
That is not
Yeah.
it. But same
He is
is
not missed the bus because of lack of education
Lordship.
or not meeting the eligibility. He
Because
says
in
that
the-
he should be given some weightage
Yes.
for the period rendered.
But
You have filed affidavit.
I have filed, but if I can't give weightage, Lordship, but I have. Because it is there, if he applied prior to this, before the DSC, Lordship, I'm still ready to cooperate, but how can I?
Okay. Mr. Bhuya?
Other Lordship, although it's 16 years or more, it's working law, 16 years or working to what between and college authority. Or is that there's the internal arrangement between the college authority. Regarding basic pass difference, act rules and other things that are no different.
The advertisement itself stated that the education qualification would be 8 pass. So there is no issue.
So basic is different. Different habit. Basic pass is some difference. Don't have still
Hmm?
Second one. Okay. That's all.
My lord, 7 posts were advertised, 5 have been filled. In which category it has not been stated? So if there is any vacancy wherein I can accommodate it.
See, in
After the vacancy
Umadevi,
started.
Umadevi, it has been very clearly said that as a mandamus of from the court, it is not possible. But if the administration on its own volition wants to give certain weightage, it is up to them. But as a matter of right,
As a matter of fact,
you cannot claim. And since
Because
you have
there
been
is no
continued in
specific rule,
contractual basis, if they think that you should be given some,
weightage,
not weightage, kind of,
some relaxation or
not as relaxation, some that your tenure is secured. It's up to them. 16 years. What is your age now?
I'm around my lord,
Heard. This was, Land Council for the
around 40, 37
petition.
or 38.
Duta cases. Kintu eta the name of the respondent, petition number 2 has been struck off.
Struck off.
Petitioner. Also heard 3. SB, Standing Council Education, D. Mohanta, Learned Council for the respondent number 3 Des College, and 3 M. Ahmed, Learned Council for the private respondent numbers 5 to 9. Oh, 3 and 4. Reserve for the we'll not have time to dictate now, otherwise we'll have the judgment maybe within 2 days or 3 days maximum. Okay. Reserve for the, huh?
The order dates that I had given, my lord, specifically struck off.
At a liquidity, this one tomorrow coming. Petition number 2's name have been struck. Oh, struck off. Mudlikha Hassan. Mr. AG, your matter, this will take some time. You have filed some application. That is, we'll just pass an order. You wait for a while?
No.
Okay. Otherwise, the matter is fixed when?
11th.
11th. We have just noticed some new application has
Yes,
come.
new
Okay.
application.
You like to file objection over?
Yes, ma'am.
Oh.
Definitely. If they have no objection, there is no case there.
He says,
And
he says yes, and that too supported by definitely.
because we are taking a cue from Lordship's order, which went against us, we are relying upon the same principle now. Now it is their turn.
Heard 3D Saikya, Learned Senior Council, for the applicant who has filed this application under section 86 of the so-and-so, praying for so-and-so. Issue notice.
There is a interim
Three-
period, Lord. Only the issue is, Lordship, that on 6th of November, our period of 90 days will be over. So as this is the issue which is required the preliminary hearing, Lordship. The IA which we have filed today, that will amount to a preliminary objection and
That is up to you. You can file it before that. You may not file it. We cannot stay the proceedings.
because the main proceedings, Lordship, some protection may be given to us.
Oh. It will be against law. Day-to-day hearing, 6 months. that will
Then
be against-
in that case, let the matter be taken up on 6th, Lord.
See, we are nowhere to advise you.
No.
Even in a suit,
The notice may be given to them.
no, we are
returned into
issuing
the-
notice, but irrespective of all, whatever will be decided here, your right to file WS
Yes.
is, at least to present the WS is already there. Whether it will be accepted or not, that you, for you, you're taking your chance. You take whatever you do.
Only thing
In
that-
a suit, we don't wait for a date for completion of 90 days. You can file it anytime. If you think that within the extended time, it's possible. We do not know what decision we'll take.
Well,
Otherwise,
how soon can you file your objection?
Well, we'll be filing within 8th or 9th, we'll be filing. Because before 11th, we are definitely going to file.
Okay. We'll have it on
yeah,
11.
because our 6th is expiring day after tomorrow. And this issue, Lordship, will be very important because this will decide, Lordship, whether the petition will continue or not.
No, that we are not staying. We are not staying any election petition. Issue notice, Sri M. Datta, learned counsel for the opposite party election petitioner, accepts notice and prays for time to file objection. Full stop. Since the connected matters are fixed on 11th of November 2020.
I'm just in identical case, there is another coordinate bench order.
You do not know what was the circumstance.
There was an application filing for dismissal of the petition on the provisions of Order 7, Rule 11.
Well, this is not an application to Order 7 Rule 11. This is under
I
86.
fully agree. I fully
This is
agree,
not an
Lordship, but
application.
the thing is that we are also praying for dismissal of the petition.
Mm.
The prayer is identical.
Mm.
In that case also, the dismissal of the petition was the same prayer. When that issue is alive, whether the petition will survive or not, the application which we have filed, it is in a
You
much
can-
stronger footing.
It is your call.
No, Lordship may record this or
Yes,
judgment
yes.
and give a,
It's your call.
or maybe on 11th, Lordship may consider the interim prayer.
See, you can file it, whether it be considered number one, you can file it without your prejudice.
No,
That you just, that if this is allowed,
my
your
submission-
disclosure of defense will not come into the way. You can still do
I
that.
fully agree, Lordship. That is a different chapter. What I am praying is that, Lordship, the main
We'll
process
consider this. We'll
on the
consider.
returnable date.
No, we'll consider your, this, order.
Today.
This order.
What?
Okay. Since, so-and-so, list, these matter on 11th. So at this stage, Sri Saikya, the learned senior counsel, has prayed for stay,
No,
of-
I'm praying for, the line is very clear, okay, that
has prayed for passing an order for exempting the applicant from filing written statement till the next date.
till the,
Till the next date. In this connection, he has also placed an order dated 29/11/2021 of passed by this court in IA Civil 1611/2021. Full stop. The reading of the aforesaid order, and it cannot be deciphered from the aforesaid order under what circumstances the said observation has been made. Full stop. Nonetheless, comma, the aforesaid prayer would be reconsidered on 11th.
Yes.
On the
Yes.
next date
yes,
fixed.
my prayer is, Lordship, not till next date, till disposal of the present IA,
উপরে লিখিবা exempted উপর কি লিখছিল exempted till
till the next date, Lordship,
till the disposal of the
disposal of the
disposal of
instant
the disposal of the IA. Will-
highly
will-
upset.
But ensure filing of your objection on 11th,
Yes.
before 11th,
Yes,
and give advance copy to them.
yes.
15.
Or it was, no? Yes, Mr. Goswami?
That is page 32, my lord, last page of the
Of the review petition. Review
court's
petition.
order, my lord. Yes, my lord. The court's order, my lord. There are 13, my lord. The court's direction was, in view of the aforesaid discussion, the court is of considered opinion that interest of justice would be served and equities would be balanced if a direction is issued to the notional benefit to the petitioners at least from the date of expiry of 6 months from the judgment dated 15/5/17 passed in WPC number 279/2015.
Yes.
As it was the time prescribed for considering giving such promotion, the court is fortified by this fact that the eligibility of the petitioner is not in doubt, as the department had itself granted them the promotion on 10/1/20 to the post of assistant engineer. It is made clear that the benefit to be granted to the petitioner would be only notional and they would not be entitled to any back wage. Further, under the peculiar facts and circumstances, the present order would be confined only to the petitioners, as the earlier direction passed by this court on 15/5/27 WPC 279(1) was only pertaining to them. Accordingly, order would not be precedent. Well, what happened in this case, my lord, the petitioner was 12 in number. And in the earlier case, my lord, in WPC 279, that was 2 petitioners.
Yes.
Earlier order is also
Yes.
enclosed.
Yes.
That, my lord, that question is, my lord, whether this order, which is, my lord, all the findings is in favor of all the 12 petitioners. But confined to the further, last line, further, under this peculiar fashion, the present order would be confined
Yes,
only
yes,
to
that we have intentionally
the
given.
word them, only
Yes,
one,
only the 2 petitioners.
only 2 petitioners.
Two petitioners. Because they were protected by the earlier order, not
Yes,
the
my lord.
others, not the others.
But the entire finding is in favor of all the petitioners, my lord. That if you were to come to the findings, my lord, it may seem that, and even if, my lord, that it is made clear that benefit of to be granted
No,
to
no,
the
let
petitioners.
us try to recollect what was the
My lord,
circumstances.
that everywhere is
The claim.
petitioners. Petitioners means the petitioners of this present case.
No, there were earlier cases.
Yes, my lord. Earlier case was only 2 petitioners, my lord.
Yes.
That I annex, my lord.
And yes, earlier took only 2 petitioners.
Only 2 petitioners.
Because the cause of action in this case was
It was
supported, the foundation was laid
Yes.
down by that
Yes,
observation made in the 2 cases.
Yes, my lord. That we are under ambiguity, my lord, that all the findings, my lord, your lordship, the findings in favor of, my lord, the findings started from para 10, my lord, to 31.
Yes, Mr. You are for whom?
AG,
Anything? Don't say. Part 3, C. Goswami Learned Counsel for the
Because earlier 27,
applicants who by means of this application has prayed for review of the judgment and order dated so and so passed in WPC 5123 of 2020. Full stop. Also heard Sri B. Sharma, Learned Standing Counsel AG, appearing for the response number 5. Full stop. The present review has been sought for in connection with the observation made by this court in paragraph 13, whereby the benefit of the order was confined to the petitioners who only confined to those petitioners who were the petitioners in WPC 279 of 2015. Full stop. For ready reference, paragraph 13 of the judgment is extracted herein below. Full stop. Para. Sri Goswami, the Learned Counsel, has submitted that when the petition was allowed and the benefit appears to have been given to all the 12 numbers of petitioners,
yes, my lord.
comma, confining the same to only 2 out of them who were the petitioners in the earlier WPC 279 of 2015 may not be proper, and therefore a clarification be granted that such benefits be given to all the petitioners in the
Present
concerned WPC
5123.
5123 of 2020. Full stop. Para. The aforesaid submission
has been duly considered. Para. The writ petition, the order dated 5/8/2024, by which the writ petition was disposed of, I had taken into consideration the earlier direction passed by this court on 15/5/2017, passed in WPC 279 of 2015. Full stop. 15, in which there were only two numbers of petitioners. Full stop. However, in the subsequent WPC 5123 of 2020, apart from those two petitioners, comma, there were 10 other petitioners. Full stop. This court had taken into consideration that the foundation of the case was based on the earlier direction passed by this court, wide order dated, judgment dated 15/5/2017, which pertain to only two numbers of writ petitioners. Full stop. In view of the aforesaid facts and circumstances, comma, this court had taken a conscious decision and accordingly directed that the order for that the order dated 5/8/2024 would be confined only to those petitioners who had earlier approached this court in WPC 279 of 2015. Full stop. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that no case for review is able to be made out in the instant application. Full stop. Even otherwise, the powers to be exercised by this court under review is a circumscribed one, wherein only under limited conditions, comma, such powers are to be exercised. Full stop. In the instant case, none of those conditions conditions exist, and therefore the instant petition is dismissed.
For clarification only,